that the stay petition may be vacated because their service has been regularized with a condition that they have, if the cases are pending, they must already be removed.
So that is totally illegal. If there was stay order, then how could they be regular?
That is why I have to respond on because regulation is filed in their favor by the state government. The state government take a decision to regulate the two of them.
According to you, the state government has violated the order of this.
No, neither. Because during pendency of the operation of this Supreme Court, the Water State Department took a decision.
Mr. Counsel, you are saying that this court had stayed an order passed by the learned single judge.
Yes.
Learned single judge had directed for regularization.
Regulation.
No, despite the order passed by, stay order passed by this court, services of two persons have been
regularized.
So the state government has committed contempt of court by violating interim order, by regularizing
Decision on the basis of the severity. Because they are eligible for regularize, they took the decision. That is 28% they have regularized, out of it, 2% are there. My responsibility, my time is on 34/2024, I am going to retire. After 15 days, I will retire. So my responsibility is appropriate order will not pass. It will highly prejudice.
No, that will not.
Mandate for appropriate order.
So when was the order of regulation passed?
Regulation passed by in the year 2023.
Then why are we making 2024?
Because recently they have passed. On 15/4/3.
Now, a copy of memo is served on me. I have already sought for instruction. They are coming tomorrow. So,
who are coming tomorrow?
The department.
Let them come.
Yes, I have already contacted with the engineer in chief. He told me when judicial order is passed, you cannot do, you obtain a suitable order from the Honorable High Court.
He proceeded for contempt of court. He has violated the interim order of this court.
I have filed a petition for
vacation.
Madam, I have filed a petition for vacation of stay.
When did you file?
Madam,
when did you file your
application? 3 days back, my lord, I have filed.
Give her that slip. IA only. For vacating the order of stay. Because that order, if the order, if the interim order is to be vacated, that shall be vacated for all persons.
No, madam. Because it's not true. Yes, sir, I have for the response 25, 525 and 510. That the 2% file they refer to vacate for
we'll hold him for contempt. We will hold him up for contempt. Give us slip. Give us slip, we will see. Monday.
You took note of IA. You took note of IA. Yes. He is not able to place it properly. I will do that.
I may pardon mention, my lord, one content matter. Under this one
contempt matter, no contempt matter is urgent.
In this case, this one court, as per order 4/2023, setting aside the order of the Honorable Single Judge and direct the opposite party to allow the petitioner to resume his duties and also directed to appropriate orders in this regard will be passed by the government of the college.
Give that slip to him.
Not later than 15 days.
Give that slip to him.
My lord.
Yes.
I don't know final point to withdraw.
Fine withdraw.
Memo filed.
Memo.
Yes, admission item number 1.
May it please your lordship. Petitioner, though possessing the requisite qualification as per the regulation, is barred from getting selected for the Hindi teacher, your lordship. Last occasion, your lordship directed me to file the need copy of page 37 and 38. 38 reflect that he possessed the training qualification since 1993, your lordship.
That means single judge has decided the issue on 2 aspects. One is you did not have the required qualification. Second thing is 14-15 recruitment process is long since over. So nothing can be done at this juncture.
So far as the second point is concerned, your lordship, there is vacancy.
Don't forget, you did not have the qualification.
Your lordship, I have the qualification, required qualification. Your lordship may kindly see page 46, 45 and 46.
See, that is in factual adjudication made by learned single judge. If that fact is perverse, you could have taken recourse to review.
They ignored I do purchase the training qualification. I have annexed the qualification, but they dispute that is not my training
The
qualification.
finding of fact by this learned single judge is erroneous. That is what you are saying. He ignored certain documents which you have enclosed. So that tantamount you should have taken recourse to review or retaping.
I have filed my retractment before your lordship.
Come to page 43.
Lordship.
What is the eligibility?
Eligibility at I possess Hindi training.
Just a minute. What is the eligibility prescribed?
Eligibility prescribed that he or she must be a citizen of India. He or she must have passed the high school certificate or an equivalent or higher examination with Odia as a language subject, or second point, he or she must have Odia as a medium of examination in one.
Which qualification you did not have?
I do possess the Hindi training certificate, the training qualification, your lordship.
So which qualification it has been found that you did not have?
B.Ed.
Where is that requirement?
Your lordship, at page 45 for Hindi teacher. Starting from page 45.
Just a minute. Yes.
Point F, Hindi teacher. Bachelor's degree from a recognized.
Just a minute. So what is your class, your qualification?
My qualification is B.Ed, your lordship.
You have rational qualification in Hindi.
Snaptak with Hindi teacher training qualification.
No, tell us, how do you qualify under this clause?
Your lordship, here this says that the both your lordship, may kindly see page 46.
Yes.
Page 46, I am just placing the relevant portion. Here they have said that BHED course, a course prescribed by NCTE from an institute recognized by NCTE and affiliated to a recognized university. I do possess the training qualification from this institute, your lordship.
No, but this is this qualification you are required to have with the other qualification which is mentioned above, and Hindi Shikshan Parangat from Hindi Sansthan.
Hindi training teacher certificate is equivalent to Hindi Shiksha Pranagat, and equivalent is there in the advertisement itself, your lordship.
Madam, this is different. See, this qualification you have BHED.
Your lordship.
You have BHED.
Yes, I will.
Only because you are having this BHED, you cannot be said to be qualified, because this has to be seen with and this qualification. And this qualification that begins from F
Your Lordship.
plus degree from recognized university and BA sheet.
Yes, I am qualified with Snaptak. Snaptak is BA. Thereafter, I am
After is
BA.
BA in particular subject.
Thereafter, I acquired BA.
Do you have qualification of BA in Hindi?
Your Lordship. That is my certificate at page 37.
37.
Your Lordship. 37. Page 37.
So Hindi Shiksha Samiti Orissa giving you the certificate of Hindi Snatak.
Your Lordship.
So that is equivalent to
No,
any
not
of the
that.
categories.
Not that.
You
That's
demonstrate-
the qualification.
You demonstrate that qualification is reflected in the requirement specified in the advertisement.
Your Lordship.
You have BA qualification.
Your-
Then you have to have one of the
Training qualification.
training qualifications
Yes.
qua Hindi as per required items given, enumeration given in the advertisement.
Your Lordship.
Shows.
Your Lordship, the next page kindly see, Your Lordship may kindly see the next page 38. 38 is my training qualification. And as per the advertisement, Your Lordship may kindly see, my qualification is equal to Hindi Sikya Pranagat. Why I say so, there is equivalence and I will prove that the my qualification is equivalent to Hindi Sikya Pranagat. Your Lordship may kindly see page 44, the qualification, about the advertisement says about the equivalence, Your Lordship. At point D,
Where is that equivalence?
point D, 44, page 44.
Particular.
Your Lordship.
Yes.
Point D, such outside university or institute candidates shall have to produce the authenticated proof of equivalency and NCPE recognized in support of their qualification at the time of verification. So I do purchase the training.
Where is it? Where is it?
Here they have prescribed that equivalency qualification is
So you
also.
produce that equivalence. Where is
Your
it?
Lordship, Your Lordship may kindly see. Next, page 54. Your Lordship got page 54.
Yes.
Page 54, point number 8. With regard to equivalency of Hindi teacher training certificate course with that of BA degree, the Principal Hindi Training Institute Cuttack has clarified that the course syllabus and the status for Hindi teacher training certificate course have been increased to a higher level, which is equivalent with that or Sikya Sahayak Pranagat course conducted by the Central Institute of Hindi Agra. He has further clarified that the duration of re-examination, that is HTPC, this is my qualification, Hindi teacher training certificate, or Hindi Sikya Pranagat and B.Ed are same, that is 1 year duration and their course are equal in content and recommended for declaring Hindi teacher training certificate course as equivalent to B.Ed degree.
You have Hindi teachers training certificate course from the Board of Secondary.
That's it. Thereafter, for service also, this resolution at next page, page 55, says that HTTC qualification is equivalent to B.Ed. So I purchased the B.Ed qualification, Your Lordship. B.Ed qualification with BA with B.Ed.
Yes.
Thereafter, if you
My lord, she should have pointed out in the beginning. My lords have heard it on 5/4/24. My lords will remember a similar case. My lords heard judgment is reserved on the very same point.
Then you will take up.
Yes, sir. Because my lords on 5/4/24 observed that after the judgment in that case, this case will be taken up.
And in many cases, we have, this court has already settled the issue.
My lord, and now what she was placing, my lord, may kindly see page 46 once again, please.
No, let that judgment come then.
Because she is reading half.
What is that? What is that? What is the case number?
I will give that.
862 of 2022. 862.
862 of 22.
WA. Read appeal.
This matter on 4 weeks awaiting a decision. NCWJC number 862 of 2000.
WA number.
WA number.
486.
862.
862.
486.
2020.
Yes.
Your Lordship, I do have a judgment of Honorable Apex Court which defines the meaning of meaning of equivalency. If your Lordship permit, I would like to place this in. The most relevant portion is paragraph 8, your Lordship.
Have you mentioned the paragraph?
I have prepared a short note of submission that I have. Your Lordship, may kindly see paragraph 8. The word equivalent must be given a
We
original.
understand, madam.
Your Lordship,
We may understand the meaning of equivalence.
Your Lordship, and along with that, the latest judgment decided by Honorable Apex Court.
These judgments,
Item number 2.
Supreme Court ने खरीदी कर
May I please, your Lordship? Here is the only question. The order has challenged annexure 1, page 15. There is a deposit of statutory amount. I don't dispute so far the law is concerned. I only dispute the fact that during pendency of the appeal, I had paid 5 lakhs rupees before the executing magistrate while execution. So I only pray that when the demand is around 13 lakhs 79,000, so they now ask me to pay around 4 lakhs some more towards statutory deposit. I pray that 5 lakhs rupees which I have paid during pendency of the appeal before the magistrate on account of this, so that has to be adjusted.
You are challenging this order.
This order, yes, please.
So what is wrong with the order?
Order is he has not allowed me to on that 5 lakhs rupees which he has taken during pendency of the appeal before the magistrate during execution case.
So this order has been passed by whom?
They passed the RERA authority.
Appellate authority.
No, appellate authority. RERA appellate authority in appeal. Under section 43, there is a statutory 30% has to be deposited 43(5) of the Orissa Real Estate Manual. So there is a provision that
You are challenging this order 9/10/2023.
yes, my lord.
What is wrong in the order?
In this order that he has not adjusted that 5 lakhs rupees. He has calculated, the office has calculated to make deposit of 30% on 13,79,000.
Let us see the provision.
That is 43(5). Section 43(5).
real estate.
Any person aggrieved by any direction or decision of order made by the authority or by an adjudicating officer under this act may prefer an appeal before the appellate tribunal having jurisdiction over the matter, provided that where the promoter files an appeal with the appellate tribunal, it shall not be entertained without the promoter first having deposited with the appellate tribunal at least 30% or with penalty or such higher percentage as may be determined by the appellate tribunal. So my humble submission that during pendency of this appeal, I have paid him 5 lakhs rupees in before the executive magistrate in execution case. So that 5 lakhs rupees have to be adjusted so that calculation should be made after deducting that 5 lakhs rupees from this 13 lakhs or 13 lakhs 79,000. And on that amount, I will make the payment of 30%.
No, but where did you make the payment?
That payment was made, my lord, in execution case.
So not before the appellate tribunal.
Not before the appellate tribunal. That will be the execution case. Arising out of the same
Please see the proviso.
Yes, my lord.
The amount is to be deposited before the appellate tribunal.
Yes, my lord. So before deposit, my lord, in execution case out of this same order. While execution case I have paid.
Mr. Patnaik,
Yes, my lord.
you have deposited pursuant to execution proceeding.
Execution proceeding.
So that is discharge of part discharge of the penalty imposed on you.
Yes, my lord.
But you are moving in the appeal.
Yes, my lord.
So for entertainment of appeal, pre-deposit is required.
Yes, my lord.
This pre-deposit cannot be appropriated towards this.
No, that is what my submission, my lord. And notice has not been issued. Notice has not been issued.
An order dated 9/10/2023 passed by the, what is the name of the tribunal? The Real Estate. Orissa Real Estate Appellate Tribunal under the Real Estate, constituted under Real Estate Bracketed Regulation and Development Act 2016, is under challenge in the present writ application. First off, Section 43 bracketed 5 of the Act provides for appeal against any direction or decision or order made by the real estate authority. Which authority is that?
Odisha,
The real estate regulatory authority, RERA.
Odisha Real Estate Regulatory Authority.
Odisha Real Estate Regulatory Authority. The proviso to subsection subsection 5 requires payment of 30% of the penalty as a condition precedent for entertaining an appeal. Stop. An application was filed before the tribunal. The petitioner has filed an appeal before the tribunal. He also filed an application before the tribunal seeking waiver of statutory deposit under the proviso to subsection 5 of section 43. Learned counsel appearing on behalf of the petitioner has submitted that in an execution proceeding for
Execution proceeding is under OPDR Act. OPDR Act. Odisha from Shame Order Recovery Act.
under
Arising from Shame Order.
Public Demand Recovery Act for recovery of the penalty imposed upon the petitioner, the petitioner has already paid a sum of rupees 5 lakh. Stop. He submits that the amount which has already been paid by him, that while computing the 30% of the amount of penalty to be paid under the proviso to subsection 5 of section 43 of the Act, the amount already paid by him against the penalty should be adjusted. This is your submission. Stop. Next. Issue notice. Yes. Requisites 1 week.
Item number 3.
Stay of an action.
No. What stay? Yes.
Item 3. That's item 3. You complied the order, you publish the record of right in favor of you.
It is not in dispute that this court's order violation of which has been raised in the present contempt application has been fully complied with. The contempt proceeding stands stopped accordingly.
Item number 4. That this case, lawsuits have posed a question whether the government has made any gazette notification in pursuance of Rule 3A. So also read in Rule 4 of the Odisha Government Land Settlement Act. When authorizing any specific officer not belonging to the collector to not dispose of and must hear the cases for due reservation. I told the lawsuit, I had written a letter, one more chance being given so that I can respond to lawsuit's query.
The officers are not responding to your requests.
In fact, the officer who was supposed to have not talked with my colleague, she is not there. So I talked to him earlier. He said that Rule 4 is also clear. It says not because he is the collector. So collector has to do anything. But because of the language that the state government has to notify us. So we also wanted to know whether it has been notified by the state government, authorizing that specifically whether collector or any officer to deal with reservation cases. That is the only sort of instruction. Next week only I can whether they will, nowadays
all these applications are being dealt with through alienation cases by the collector only. In view of this provision, not because of the collector. But whether there is any specific notification authorization or not, they are also wanted to know that. The rule 3, section 3A and rule 4, both says, yes, notification, what is there, yes, by the state government.
But then it's a very serious matter.
Yeah.
Whether any officer has been authorized or not.
That is the specific instruction also wanted to know to produce the given notification whether state government has authorized the officers to, so I think, next week we also I can obtain the instruction from the Secretary of Revenue because
Requested by the Council and place this matter on 1 week. So as to comply with the order dated 5/4/2024.
Item number 6.
Interim order is there.
Interim orders that continue. Interim order, why interim order?
That is status quo order was there.
Status quo order, why are you interested in a status quo?
So they are progressing for the development.
This is PIL.
Switzerland has been given to DSP construction.
All right, the interim orders that continue. But you are, this is PIL.
Yes, yes.
Item number 6. My lord, yes. My lord, in this case, my lord, the petitioner seeks kind indulgence of this honorable court regarding the inaction of the authorities not releasing the land earmarked for the construction of the post office, my lord. Last occasion, my lord, directed to appear the city authorities and accordingly appear. So just now I received a copy of the petition. Please, my lords, Saturday and Sunday it will be not possible, my lords. Tuesday or Wednesday, my lords may fix. But so whatever instruction yesterday night I got that idea and I collected from the law officer may not be sufficient manners because he is not the authorized person to say so. As fact remains, these lands forms part of the planning area, but premium free land. Suppose that 100 acres of the land is given for the development of the project, and CBA makes out a plan for the residential and other commercial purposes. But road and other public amenities, these are all premium free land. CBA doesn't get return payment of the premium. These lands are generally transferred to members the collector, and collector is authorized to deal with this. And that is what matters. We requested the collector. Here, collector is competent because we have already given handed over the possession. We are requested to take over possession. So this particular plot, is being carved out for the purpose of the post office as per the plan. Now, collector is competent to hand over that to directly to the post office. That is what my information, information. Now, if you permit me, I will get all the detailed particulars, what is the subsequent development, all of these things, so that my lords will be able to.
Land is vacant or not?
Yes, land is vacant, my lords, because it's a carved out land, my lords, in the planning area.
Then do it quickly.
But that now collector can do. Because this land, after carving out the.
Collector is a party.
Yes, ma'am. My lords, just to soft copy, my lords, the party, my lord.
Respondent 4 years.
I will bring these publication.
With the district magistrate also.
We will try our best.
Lordship, I will offer instructions because they have written a letter to take back the possession of the plot to the collector. The CDI, Lordship, may grant me 7 days.
No, sir, no, submit 1 minutes. Kindly be asked to, my friend, just now I got.
These are paper formalities which can be done
These are all paper formalities.
without any loss of time.
Lordship, we'll take it immediately because the letter is there in favor of the issue to the
All right, we are adjourning it for a week.
Yes, ma'am.
In the meanwhile, you please ensure
Lordship.
that if there is any communication by CDA, you take back the possession.
Lordship.
And in the meanwhile, if possible, you may, we can give you 1 more week time.
Lordship.
Allot that for the post office.
Lordship. Lordship.
May I add only 1 minute? Kindly be asked to.
Central government is a party.
I am for this as welcome. Let me start the copy. Yes, we'll start. That, I think all of you. Yes, yes.
Inform after 2 weeks.
Right.
This matter on. Issue notice. Mr. So-and-so accepts notice on behalf of Better Development Authority. Mr. So-and-so on party number so-and-so, Mr. for the state review and let the visit number of the execution be served upon and counsel for the opposite parties in course of the day. List this matter on 2 weeks. First off, in the meanwhile, the opposite parties shall be under obligation to inform this court as to whether the land earmarked for a post office by the Qatar Development Authority has been made available to you.
Is to, unless the collector handed over the land.
To the concerned authority or not for establishing a post office.
No, a small request, my name may be reflected in constant so that I will not be.
Let names of the parties, let names of counsel representing opposite parties be displayed in the daily cause, in the cause list.
City and central government,
Or and state also.
state.
Item number 7. Moving forward. Well, I am for the petitioner, man.
There is no petitioner, there is a appellant.
Yes, ma'am.
7, sorry.
Petitioner, man. I am challenging the Dewar dated 29/10/2004 in ID case number 275/95, passed by the Land and Presiding Officer, Labour Court, Bhubaneswar.
So why it has been,
Under Annexure 8, ma'am.
why has this matter been listed for orders?
My lord, last occasion, it was already closed, my lord. Your lordship declared that orders will be passed. Then I saw it has come on the orders matter. Then last occasion, I was not available. We pray only, my lord, the reinstatement not possible because stage is over. Since we have completed 240 days and more, 25F has been violated, some lump sum compensation amount may be granted, my lord. Well, similarly, this honorable court in another case also granted.
So we have to pass orders only, no?
Yes, my lord. I am citing here. Hello.
So your date, I've seen. Huh?
And another also Supreme Court decision I am saying. Hello.
All right, we will hear from you.
Only lump sum compensation amount will pay, my lord. Scheme is over in the middle of the scheme, in spite of completing 240 days, we have been terminated service. Type copy of consultation fellow repeat also I am submitting, my lord. That will be very clear how 240 days workman has completed. My place the fellow report.
What is wrong in the order, wrong in the finding of the tribunal?
Well, tribunal is of the opinion that no relief granted because we have not completed 240 days work in the.
Not only that, because the scheme also is soon closed.
The middle of the scheme I have been terminated from service.
But nothing can be done now.
No, room settlement not possible, but compensation possible. In their counter running paragraph, running page 40 into the 40 to the B, in their counter paragraph 10, they have admitted that as regards to paragraph 12.4 of the writ petition, it is respectfully submitted that though the workman had completed 240 days of continuous service as casual laborer on daily wage basis, because of the temporary nature of the scheme and his engagement, question of retrenchment compensation does not arise at all. Further, he had never been detained or terminated by the management before closure of the scheme. My lord, they ceased to work from 26/10/85. 26/10/85 is the middle of the scheme, my lord. The scheme, they have also admitted that running page 43 to their 43, annexure A1 to their counter, my lord. Last paragraph, it may be noted that no report has so far been received on the allotment of palms of beneficiaries or otherwise from the state government. It is therefore requested that a factual report indicating the actual number of palms existing, number of palms in the bearing state, allotment details of these palms to the beneficiaries, number of beneficiaries belonging to schedule caste, schedule tribe, etc. may please be arranged to be furnished to the board during the period from 82/83 to 87/88. The board has released a total of the amount of 85.917 lakhs as its share for implementation of this scheme. Next para, it may also be noted that since the original sanction for the scheme is up to 88/89, only the grant in aid from the board will be discontinued from 89/90. So the scheme was operative up to 99. But in the middle of the scheme, they have refused employment. In spite of I have completed 240 days work, the clear mandatory provision of 25 work has been violated. In spite of that, the labor court awarded no relief. That is the. It is the only claim I have some lump sum compensation.
All right, we will decide it Monday. Monday we will deliver.
Item number 8.
I'm for responding.
You are for the other side.
Your Lordship. Yes, Lordship, item number 80.
Yes.
Yes, Lordship, item number 80 may be taken up next week due to some defect as pointed out by the office.
Just a minute, Mr. Counsel. Please wait.
Your Lordship.
Yes.
Your Lordship. Item number 80, some defect is pointed out by the office, the stamp reporter. And I am ready to remove the defects in course of day. And accordingly, this matter may be taken up next week, any day fixed by the Honorable Court.
You remove the defects first, we will see when the matter shall be taken up.
In 2023, an order is there. You are remove the defects, but as yet you have not.
No, the defect number 5 is D.
11th May 2023.
Your Lordship, I am
Remove the defect.
Your Lordship, listen, what is my inconvenience, Your Lordship? Today I am not ready to hear the matter against the impugnator, but defect is pointed at the office. First of all, I am going to...
Mr. Counsel, in May 2023, you were asked to remove the defects you did not remove.
Now, Your Lordship, today
After 1 year, you want time to remove the defects, and you also want that the matter should be taken up on priority basis.
Your Lordship, I consider.
Highly unreasonable. 1 week time is allowed for the Learned Counsel for the petitioner to 1 week further time is allowed. Counsel for the petitioner to remove the defects, spelling which this application shall stand dismissed without further reference to the bench.
Item 9. Item 9, Your Lordships. Office has pointed out that 6 days limitation is there. In fact, from the order sheet, it reveals there is no limitation, but office has pointed out 6 days limitation. I have also filed one IA number 2001 of 2024.
That we can control.
Madam, what has happened? It was listed on 16th. I mentioned the whole Lordships to bring this IA along with this appeal, but it cannot be listed.
IA has not been listed.
No, IA has not been. You Lordship may condone the delay because 6 days, you Lordship may kindly see.
IA is not there on record.
Yes.
Yeah.
If you Lordship,
IA be there on record.
yes, 2000, you Lordship may 6 days delay.
You cannot decide an application which is there in your file.
Right. No, that's true, Your Lordship. But fact means Your Lordship may kindly see there is no delay in fact. That is wrong in nature.
All right.
There is no delay. Your Lordship may kindly see order is passed on 27/3/2023. And the appeal was filed on 2/5/2023.
But for that reason, you have filed IA.
No, what does appeal, Your Lordship?
No, you have filed
I have a certified copy period has not been taken into consideration whenever SR was made.
All right, we will allow your limitation application. Let that be there.
My solution is there is no limitation at all. Wrongly, it is shown as limitation.
But you have filed IA. That IA,
Unless I had not filed IA, it could not have been listed. That is the whole problem. Therefore, I am compelled to file the IA. Anyway, when we bring the notice of the solemnity that so it is the there is no alternative. Now what is going on now as per the notification? Even Lordship may consider that there is no delay.
Monday, along with IA number
IA number 2001 of 2024.
2001 of 2024, which is said to have been filed on when?
That is filed on 15/4/2024.
15/4/2024. क्यों नहीं लगा होगा? And what is the system?
So electronically it could have been tagged up. Since it was filed in imbue. Electronic board was filed. So it could have.
Had you e-filed your IA?
Minor.
E-filing?
Before the counter, you will
No. Physically you have filed or
No, but physically I have. Physically I have.
It takes time.
Physically I have.
That have been filed on
15/4/2024.
Had you filed that electronically, that would have been tagged.
Physically it is filed now. It is filed physically in the counter. In counter, my lord,
So Mahapatra, my lord, is saying that had you filed electronically, it would have been easier to tag it with our electronic sign.
I am sorry.
So what difficulty do you have in filing your application electronically? We are just trying to understand.
No, but counter is there. It is very easier to file the application in the counter.
We are in a mode to switch over to electronic form and digitization form.
That's true.
So
those facilities they have before this honorable court that it is to be filed before.
To say unless we stop that practice of filing of physical mode, you won't switch over and you won't accept the advancement.
In fact, we are expecting this thing, a request from the members of the bar that we should go for complete e-filing
Totally to make it paperless.
Make a request.
We will try to lots. We will try.
Make a request. Let the members of the bar make a request.
We are making an attempt. It will be very difficult now. Nowadays, my lord, we have to get training to our all this.
Get training. It is difficult. Which staff?
But we have to, my lord, to our advocate clerk and all.
How many?
For all the members of the.
We will give training to all your clerks.
Actually, master trainers are already there.
Make a plan. We are ready to train all your clerks. And we will start from clerks.
All right.
And then lawyers. All right. Is there any association of advocate clerks here or not?
Yes. We are all the advocates, maximum advocates.
You can train them. All right. Next. Item number 10.
You will also be posted to Monday. Right. Deep look.
The item number is identical to item number 9, my lord. Because there is no delay, but officers pointed out 3 days delay. I have filed an IA 2039 of 2024 on 16/4. That has not come, my lord.
Move this matter on. So and so along with IA number
2039 of 2024.
we can file for condonation of bail.
And other defects have already been removed, my lord.
It has been stated by learned counsel for the appellant that rest of the defects have been removed.
It will come on Monday, my lord.
Item 11.
36 days delay now. 36 days delay.
That's not quantified by.
Or not pointed out by, so they have not filed any dispute for the condonation of the. But this is a matter that principal secretary of the government of Odisha.
All right.
But I filed this writ application challenging one regularization.
No, no. This matter has come for condonation or delay.
Yes, madam.
Not
Ma'am, 76.
certified copy.
Ma'am, Mahapatra, Ms. Mahapatra, 7657 of 2023, IA. Do you have the copies of by Mr. Misra? You don't have.
I have not stopped my.
But what?
This is a.
So we are not going in merit. First we are taking up the matter on limitation.
But this process has become punishment for this respondent, my lord. He is not getting salary for last 1 and 6 months because of the pendency of this writ appeal. And on my mention, it was listed. They are not taking any step to list it because this is pending and there is no movement in the contempt. From 2007, my lord, against a sanctioned vacancy, created vacancy.
We are not on merit.
It's my lord, that I know, my lord. That's a very lost.
So should we allow it? Application for condonation or delay?
My lord. Condone.
IA number third so and so. IA number 7657 of 2023. There is delay of 36 days in filing this writ appeal. And counsel for the opposite respondents
Respondent 1.
does not oppose the prayer for condonation or delay. Stop. Considering the averments made in the application seeking condonation or delay and submissions advanced at the bar, this application is allowed. Delay stands condoned. Yes, what more do you want?
Well, this is the matter. Well, I am for the respondent, the finance secretary of the government of Odisha.
Madam, he has right to argue his appeal.
If he has all the right to not to do, not to give instruction, not to regularize, every rights are with them, madam. We are the poor person.
We don't know. We don't know what is happening outside the court, but inside the court, yes, he has right to argue his appeal.
If he said because before your lordship, my lord.
All right. Yes.
My lord, may kindly take up this matter for admission next week?
When, madam?
When?
When do you want?
No, next week, my lord, I'll be there.
Well, counsel appearing on behalf of the respondents has submitted that considering the plight of the respondents who are not getting their salaries because of due salaries because of pendency of the present seal, its hearing may be expedited. So list this matter on 2 weeks within first 5 cases. What else?
My lord. Next week.
Mr. Misra, Patita Pavan Dattadas WP number is referred to in this case.
Well,
So that was confirmed in writ appeal.
well,
Thereafter, have you preferred?
now the state.
It's
Item 12.
Respondent number 2A. I am praying for a short adjournment. I have already taken consent of the council for the appellant.
Yes. When did you join?
Sorry, Your Lordship,
When did you join bar?
2021.
And when had you passed matriculation examination?
Matriculation, 2011.
And this this petition was filed in 2001.
I understand the lordship, we were served notice on substitution. We have entered our appearance in the month of February.
This AHO?
It's a rate of progress. Rising.
CPC. Acha, section. It is series of 101.
Yes, what do you want?
I want an adjournment. The conducting council is out of station. We need to go out in an emergency. I'm saying if it could come on Monday also, we will be ready by then.
We are adjourning this matter for a week,
Your lordship.
but we want disposal of this.
Yes, your lordship.
All right,
Yes, your lordship.
Lordship on Monday, matter was taken on Monday.
1 week.
Monday, your lordship.
Why?
You are for petitioner.
Yes.
She is for respondent.
Yes.
Or the opposite party. Respondent.
Yes.
So you are opposing?
Your lordship, maybe adjourned for today, your lordship, but it may be taken up on Monday. So Monday or Tuesday. Your lordship.
Monday, your lordship.
As jointly requested, list this matter on Monday. Item number 13.
Similar order, once satisfied copy has been given, and
Can you use the mic? You don't have.
Yes,
yesterday similar order has been given a certified copy. That has been that order has been issued.
ID. But why are you relying on this?
That was yesterday I have given a certified copy of the order. On view of that order, this order was passed. Your lordship, last time only one copy was there. But it was that's why I thought your lordship because I have given to.
May submit.
And relying this judgment, the present case, present interim order has been passed. And here also, on para 21, the entitlement has been decided by the honorable single judge.
Yes. But basically, upon this judgment, madam, that order was passed, which was challenged. This order was also challenged before this honorable court by the corporation. And during the pendency of that writ of appeal, my lord, this order was disposed of on the ground that lordship can have a glance to it. Page 4 of that judgment. Last paragraph. May I read, ma'am?
So in this rate petition, all the employees were of the corporation.
Yes, madam.
Huh?
From STS, but the honorable single judge decided a matter taking it as a whole as a corporation employees. But when the cases were pending there the government were sanctioned in respect of those cases, that Mahendra Mahathi and others cases, because they were originally from the STS employee. And they came in 1974 when the corporation was established, and we are the direct, we are recruited by the corporation. But the honorable single judge decided a matter whether the corporation employee will be entitled for the benefits or not. At that time, there was no discussion about the STS employee or the parents employee.
No, but the difficulty, Mr. Counsel, is
Yes, madam.
that the decision which is under challenge in the present appeal is based on this decision.
Yes, madam.
And this decision has not attained finality
Yes, madam.
because there is no consideration on the points decided in this appeal.
Yes,
In this
that was there, Mr. Patel. Yes.
This single bench decision is subject matter of
What's
appeal.
the name?
Yes,
Yes,
In this rate appeal.
that is my
In this rate appeal.
read April number 373 of 2017.
So
all the cases were taken together.
question is left open where?
In the appeal. No, it is this single bench.
This appeal has been disposed of.
Disposal of on the basis of the fact that in respect of 4 and 5, they have no necessary provision, so they have allowed. But those who are not STS employees, that question is left open to be decided in writ appeals. So now we are in writ appeal. Mr. Tripathi, is it your case that single bench has decided overall, as Mr. Patra has said, against that judgment, we preferred writ appeal. In writ appeal, in respect of certain employees, those employees who were or who are STS employees, that aspect, because you have made some certain budgetary provisions,
Yes,
we allowed them.
yes, madam.
So in respect of those who are not STS employees,
Yes.
so that question is left open. So you mean to say that that single bench decision has been varied to this extent?
Yes. Well,
Is
for that reason,
it your case?
yes, your lordship is right. But for that reason, your lordship in the last 6/2/2024 directed the state government to take instruction that if they are ready to release some amount in favor of the corporation. 6/2/2024, your lordship kind of a glance.
No, that is not the question. We are trying to understand the effect of this order 15/4/2021. Apparently, the effect of the order is that there is no discussion. The points decided by the learned single judge have not been addressed.
No.
And the division bench says that those points shall be considered in other writ appeals.
Yes.
So the division bench was aware about the pendency of other writ appeals.
At that time, all the writ appeal are running.
Those cases also were taken together. These cases and the Mahendra Mahathi cases, all were taken together. At that time, the government gave the budget to those PSU. That's why honorable division bench disposed of those matters and segregated these matters.
And government's letter, which is extracted in the writ appeal,
Yes, ma'am.
that is also made clear that in addition to the facts above, all the claims received in respect of STS employees only, those who are retired under VRS and may be separately submitted to government to decide the release of funds.
And the only objection from the corporation of that economic crisis. And my that only up to that aspect I may submit my life
Your client is non-STS.
No. Yes. Not from the STS.
ST.
They are directly recruited from the corporation. So my recruit submission, there will be any.
So let us proceed from the beginning.
Yes.
How are you entitled to that state?
That's correct. As because in view of the provision that once that ORSP rules 98 was introduced, that was introduced with the prospectively, that is from 1816 to 2009.
All right. So how should we read that you are entitled for with effect from 1996?
96, as because.
See, you are an employee of a corporation.
Yes, my lord.
Your employer is the corporation.
Yes, my lord.
Corporation will decide your salary.
Yes.
So where is the decision of the corporation that you will get the same amount which the employees of the state government or they get?
On that, my my lord, when they came to the corporation in 1974, we became similar and we are getting similar benefits. Prior to this ORSP 98, we are getting same standard.
Please let us know where is that document? Where is the rule?
That rule I have.
Sir, you are entitled for salary firstly on the basis of the letter of appointment which you get.
Yes.
First. Secondly, you get your salary or whatever on the basis of the service conditions decided by not by the government, decided by the corporation. All right.
Yes.
So how do you say that you are entitled for salary according to the salary fixed by the state government for their employees?
But yes. So what was my challenge before in the writ petition? I had challenged the writ petition, challenged the order dated 18/2/2009, that is decision of the corporation to implement the ORSP rules 98 prospectively, which occurred from 18/16 to 2009. This was my.
So you want that to be cost?
Yes, that has been crossed by the honorable single judge.
So we will cross that.
Yes, my lord.
But the difficulty is that in that case you may not get that with effect from 2009 also.
We have already eaten from 2003.
All right.
Only 5 years. What is their stand? Only economic as. That is the only point there. That has been dealt with by this honorable court. But by single that is, your lordship kindly have a glance to.
So single judge's judgment is under challenge in the case.
The juvenile bench also has held in another case. I have given with my 3 judgments, that is with my death charge.
Now let us see the judgment.
Yes, madam.
Where is the judgment?
Your lordship kindly see the. Next question. I had given a death charge along with 3 judgments. That was the records, my lord.
Wait.
These are division bench. Yes, I have given. I was Santosh Korna was happy. Otherwise, you are also, I will.
Just a minute.
On the day when that Mahendranath case was submitted, on that date I had filed the.
Which judgment?
That is WA number 234 of 2018. 3 judgments are given. That is first judgment, that is 2017 2 OLR regarding discrimination.
2017 volume 2 OLR.
OLR, that is regarding to the discrimination between the 2 sets of employees.
So it is full bench.
That is the full bench of Honorable Supreme Court. But
the Supreme Court, yes.
Yes. There are 2 types of lecturers are there, that is teachers. There one for having a diploma holder and one for the degree holder. That is honorable Supreme Court held that you cannot discriminate in this manner. As because both are employees of your establishment, there can be no discrimination. You have the law to equate. That judgment I have given my.
Mister, there is difference in
they have come from the STF.
They were on deputation.
No. They are permanently observed. As because why I am saying so,
While the OSRTC corporation was established in the year 1974, some of those were STS, State Transport Service, they came, and also we were appointed directly by the corporation. And both came into the one common cadre. And we all have been getting same benefits, same scale of pay, and all the benefits were given to the both the sides. So now that all the first time the government says gave them the budgetary provision, thinking that they are our employees. Since they are our employees, we gave the budgetary provision to them, but not to the us. That's why this honorable court held that in one case that you find that they have been implemented and they have been given benefits when judgment given when judgment is there. But whatever is there stand on the economic crisis, that has been dealt with by honorable single job in both the cases. That cannot be a ground for the corporation, while others all have been given the benefits, but from the retired employee, those who are only going to get to 5 years differential salary. From 1996 to 2002, 2003, all have been retired in that time now. That's why this honorable to the another government, that is, I have given the second government which may be submission, that this honorable could hold that cannot be a ground. That is the division of judgment. That
in 1996.
Yes, I know. 1196, that is
Right, 1/1/1996. The benefit which has been given to these employees,
yes.
They were not on deputation, they were permanently
Yes, madam. They were permanently observed the corporation. That's why the honorable single judge was disposing matter, taking it as a whole as a corporation employee. That's why this honorable court had not separated that they are a STS employee or these are the cooperative, that is the corporation employee. Both are same. Both are belonging to the one common cadre. And prior to RSP rules were 1998, reviews on RSP rules have been allowed to vote. Us and also them. So how does it mean discrimination? And on the ground that only that is economic crisis. Economic crisis that was there. Now the corporation is going with
Yeah.
That is whether as per the resolution passed by the board, man. Since financial condition of the corporation is very poor, man, it was decided that there were RSP rules to be applicable from 2009 prospectively. And financial condition, what my learned friend is saying, is the only reason for that we are not able to pay the salary to the corporation employee. And this is our stand also in the before the single judge, my lord. Since our financial condition is not proper, my lord, so we are not able to grant that ORSP rules from the date. That
Why is your financial condition so poor?
My lord,
all the bus operators are earning a lot.
my lord, we see this way, all the states, corporations, financial, all the state-run corporation, my lord, are facing financial problems. Since it is a welfare state, strong corporations are not getting.
No, but how can you discriminate?
My lord, for that
You can take this plea that you did not discriminate. It is the state which has discriminated.
yes, sir.
By providing the fund. It is the state which has discriminated, state of Odisha, which has discriminated because they have set aside the fund only for them,
STS employee,
for the STS employee.
not
So
for
they
the
should have-
corporation employee.
That is the only plea.
My,
Otherwise, according to you, also they are entitled.
since the other, my humble submission, the other employees are getting that scale of pay. And budgetary provision was made by the state government, but for the corporation employee, no budgetary provision was made.
No, but you are not making any legal, this is not legal submission.
But legal,
Either-
my lord, people are, I have given a death chart, I will argue on legal matter. Since my lord, they are corporation employee, my lord, and the respondent number 1, my lord, took voluntary retirement in the year, my lord, voluntary retirement in the year 2002, my lord. After that, my lord, he has filed the application to get the revised scale of premium. Once he is accepted the voluntary scheme, my lord, he has no right to claim further, my lord. That is the decision of the Honorable Supreme Court. And further, my lord, all the employees who are retired salesmen,
They have challenged that notification.
No, they could have challenged that notification, or they could have challenged your decision after 2021.
Yes, ma'am.
They could have challenged. They can challenge.
Yes.
Because for the first time in 2021, the government officer took a decision.
Yes, ma'am. They have not challenged.
Huh?
They have not challenged that, ma'am.
No, they have not challenged. No, by the decision of the state government, they is too discriminated.
Yes, ma'am.
And if you are saying yes, then you don't have any case.
But madam, that is for that I have submitted madam during the tendency of all the appeal madam. State government has allowed their that fund madam in favor of
How many appeals are there?
my lord. There are five appeals.
And the state is a party.
Yes, madam. State is party. For that reason, your lordship has directed state government to why you are not you granted to the employees of the STS, why not to corporation? And I have filed that affidavit, and your lordship has not sought for it.
My lord, in an affidavit filed on 3/2/24, copy was served on us, and it was stated that a proposal has been submitted to the government. Now, while scrutinizing that proposal, we found that although the writ appellants, the respondents concerned are very few in number, but the corporation has raised a proposal of very high amount concerning many other employees. So, my lord, we are scrutinizing that. And if my lords will grant me
So do it. Otherwise, you will have to hold that.
madam. The problem is, madam, here, as I was going through the case records, madam, persons are only within 15 or 20 in number. But the corporation has given a proposal of more than 70 persons. And some areas from 96 prior to that, the real budgetary provision for the purpose of this case will be much less, madam.
Do it for at least for the purpose of this case. We will see for other employees later. Do something.
Mr. Patra, this Samsundar Parija case. has
My
been-
lord, what I was humbly submitting, so if the STA submits a proposal with respect to the cases here, we will immediately, my lord, take some action on that. They are giving a general proposal for many employees with many other claims. Sixth pay, seventh pay, it is not the subject matter of dispute here.
That is related to fourth pay that was paid. This sixth pay, seventh pay, our only 5 years, that is only fifth pay, but they have given taking to all. That is fourth, it was credited from like 2,000 crores. It is sixth pay regarding such and such. Seventh pay, so that's why the government will not do anything. They have given each other. This honorable court held that you file this proposal regarding this petitioner. But they filed proposal giving the entire from the inception to till today. What is the credit to them?
So, but at least with effect from 1996, all the employees are entitled to that escape.
For that reason,
From 96, from 96, that is what I was praying before my lips. From 96 to 2002, this person
Yes,
was
that is the only thing.
they are submitting prior to that. More the seventh pay, eighth pay, the proposal has come like this with a very huge amount, with no justification.
for Lordship Allah, we will file a detail about these petitioners.
Please listen to the order which we are passing.
Fine.
And if there is any mistake, please point that out.
Yes.
After the order is complete. Okay.
Okay.
the orders, various orders passed by single bench of this court, which are under challenge in the present batch of writ appeals, are based on a single bench decision rendered on 30/8/2017, reported in 2017, bracketed supplementary to OLR 289, bracketed Mahendra Kumar Mohanty and other analogous, Mahendra Kumar Mohanty versus State of Odisha and other analogous matters. First off, the decision of learned single judge was learned single judge in case of Mahendra Kumar Mohanty, bracketed Supra, and other analogous matters was challenged by the Orissa State Road Transport Corporation by way of an intra-court appeal giving rise to WA number 373 of 2017. And this was the only appeal.
No, madam, there is
And
other appeal. That's why the previous appeal, present appeal, sir, my lord, another judgment is there. That's
So-
what
a division bench of this court had has this from an order passed, order dated 5/15/2021, passed by a division bench of this court in case of WA number 373 of 2017. It transpires that in the light of a decision taken by the state government of Odisha providing funds to the state Odisha OTSRC जो भी हो OSTRC for payment of salary based on the revised scale of pay with effect from 1/1/1996. क्या लिखा sentence? नहीं, फिर से sentence थोड़ा (196) to only such employees of the corporation who were initially working under the state government of under state transport service.
Yes.
Under state transport service and were subsequently absorbed in the corporation. For the benefit of, we consider it apt to reproduce the decision of the state government as communicated to the London Advocate General, which has been quoted in the division bench order of this court dated 15/4/2021. Stop. It is the case of the appellant corporation that it does not have sufficient fund to pay to the employees of the corporation salary based on a revised scale of pay with effect from 1/1/1996, which has been implemented for the employees of the corporation with effect from 2009. 16 to 2009. First off, it has been argued on behalf of, first off, he has, however, not been able to distinguish the case of the persons who have been granted benefit, persons working in the corporation brought from the state transport service and subsequently absorbed in the corporation, and those who were directly recruited and working in the corporation. So stop. He, however, submits that the employees who were initially under state transport service have been given benefit of revised scale of pay with effect from 1/1/1996 because the state government had made available the requisite fund. First off, he has argued that if the state government releases adequate fund for payment of other employees of the corporation salary based on the revised scale of pay with effect from 1/1/1996, the corporation shall pay to them the arrears of salary and other benefits accordingly. First off, next, when counsel representing the employees of the corporation, all of whom have retired, submits that there cannot be any discrimination between the employees of the, there cannot be the decision of the state government to release fund for payment to the employees of the corporation which were initially in the state transport service and denying the same to other employees of the corporation is discriminatory and violative of Articles 14 and 16 of the Constitution of India. What's up next? Learned AGA representing the state of Odisha has submitted that if the State Transport Corporation provides to the government a calculation sense requisition for payment to the employees of the corporation salary based on pay scale as revised with effect from 1/1/1996, comma, it shall consider the same in right earnest and take right earnest, comma, take a decision and if required, comma, release adequate fund to the corporation. So stop. Next, list these matters on 3 weeks. So stop. The corporation in the meanwhile shall be the appellant in the meanwhile shall be under obligation to provide to the state government to make a requisition to the state government for payment of salary to the employees slash erstwhile employees of the corporation for payment of areas of salary based on revised pay scale with effect from 1/1/1996.
ORSP, under ORSP rules 98.
Under
ORSP rules 98 with effect from 1/1/96.
under ORSP full form.
Orissa revised scale of pay rules.
And then that is 1/1/96. 1998 with effect from 1/1/1996.
Difference.
That is area or differential salary.
Area
Differential salary. They have already got their salaries. If that will be only
area differential salary कर रहा है जहाँ भी areas है ना वहाँ area differential salary.
Legal loss. Approve the opinion to CMC matter. Personally, order dated 11/2/2024. I have filed the latest status report matter. No. That is not. I have how I have categorized. I am common.
No, I could find out.
Yes, that there will some cases there is a limitation. In that 99 cases, some cases in limitation.
Certain cases.
No limitation is there. Because this is part during that COVID period, no limitation is that I am not on. But I have categorized these 7 categories. Now there was second category 2 LSMS is that 7 matters. In category 2, I have given the chart for my lord's perusal. In that case, those cases where the counter have been filed, and after completion of the pleading, order has been passed. That relates also regularization.
That relates to also regularization.
Regularization of miscellaneous.
Miscellaneous. So, are different categories
Not confined to BLR,
not
some
BLR.
other
Right.
clerical staff is also there.
Yes.
EO is also there.
Not DF.
Data and
Not
there is
DF.
no data.
Not that.
Drivers,
Not driver. No. And third category, madam, that's also complete separate category, relying on one judgment of that this court has been, those cases have been disposed of, and those matters are challenged before the honorable. Here in writ appeal, we lost here.
Category 3.
Category 3.
What is category 3?
Category 3, madam, relying the decision of this honorable court, those matters are disposed of.
Relying on which?
The judgment filed in Patita Pavan Dr. Das case. In those cases, we have prepared writ appeal. We have lost here. Then we approach the honorable apex court that is pending before the honorable apex court.
notices are issued.
Notice issued, in contempt proceeding stay has been granted.
No, contempt stay is granted, but stay of judgment.
No, that I am judgment has not been stayed, only contempt has been stayed.
Writ appeal that was contempt.
Notice has been issued on all those cases. Fourth category, my lord. That matter relates to a regulation of the watchman. In one case, your lordship has similar matter. In one case, your lordship is hard and the judgment is reserved. That regularization of that, your lordship may say that fourth category W 925 or 2020 of a watchman in treasury.
Watchman.
My lord says the judgment is reserved in that case. Yes, 925, my lord. That W number is I am missing, my lord. That simple. I can give that number.
So you give that number.
Yes, I will give that. My lord, that.
Sorry for interruption. In that case, that is I am for the respondent. That is different because there are questioning whether sanction court is there or not.
Yes, please give the number. Please give the number.
I am saying that. So this is
That was your case. That was your case. You are appearing.
My lord,
That judgment is reserved.
my lord. But this case is different.
That is, I have segregated all your, please give the number.
My lord.
so I have segregated all those. Those are different somehow.
Binding will not bind you.
My lord. Then you will I have no because that is it depends on that result of that I will be
That is not binding. That is hard separately.
I don't, may I just take a copy of this chart can be given possible.
But I am giving this is prepared for my lord's perusal because it matter will be segregated. My learned friend is asking for that chart. Yeah, Lord, I am giving that chart also. And sixth, seventh category are also somehow different. So if your lordship will segregate into 7 categories, it can be listed in 7 items, so that matter can be disposed of. That's my endeavor before my lord, my lord. So they want to see.
Wait, you can take up these 90 matters first
Yes, ma'am. Yes, ma'am.
on Monday.
Monday, any day your lordship may fix, ma'am.
So that is the only point
Yes, that is the only point.
that it was decided on the very first day.
Very fast, it was decided on the very first day.
That day, my lord, will be addressing your lordship that stay has been granted without condoning delay. So far, my matters are concerned. I have 5 matters, including that.
Stay has been granted in the writ appeals. Without.
Yes, ma'am.
Wrongly.
Apart from the fact that I have filed a counter to the petition for condonation of delay.
No, but is it an admitted fact that the writ petition was disposed of on the very first day?
Very first day, regarding that, I will be submitting, yes, that is a fact. But regarding that, I have my own submission. Your lordship may kindly see, when the writ application is filed, an advance copy is given to the state council to obtain. It is not in cassette form. The import order passed by in the writ application is not in tacit form. It is in view of the decision what my lords other day said, it is covered by the decision of the Honorable Supreme Court. And advance copy was given to the State Council to address to the court on the basis of instruction. Even if the instructions were not available, the State Council they submitted to the jurisdiction of the Honorable Single Judge and did not waste any time for obtaining instruction or filing the counter or anything. Thereafter, regarding delay order, 30 days time is available. 3 cases were open to file the petition for recalling of the order, impugn order, to file a review, or to file the writ appeal within that 30 days. But 1 year after writ appeal is filed, after receiving the notice from the court, Contempt court, my Honorable Single Judge, what has happened when this impugn order was passed? Within that period, without complying the order, the minor state authorities for their appellate authority, not the High Court, over the order passed by the Honorable Single Judge, they wanted to reject our claim contrary to the order passed by the Honorable Court. In the cases, minor state authorities have refused and thought themselves appellate authority and interpreted the order passed by the Honorable Single Judge, my lord, and passed an order contrary to the order.
Let's me see 137, 2022 is there.
Which one?
Not me.
Very good.
137. In 137, I have also prepared my short written note. I am submitting.
Oh, please come to the order.
Page 25.
There is nothing in the order.
And this, in the certain terms, this post applying the principle indicated herein observes that in the event the petitioner is holding a sanctioned post and he has already served as a temporary for more than 23 years without any stigma in his care, the case for petitioner for regulation may be considered by the authority concerned in terms of the decision cited herein by completing the entire within a period of 3 months from the date of communication certified copy of this order. Till such period, there shall be status quo in respect of.
There is a finding.
Yes, that next page,
No, it is also found that present petitioner has already worked for.
Yes, ma'am.
23 years.
And well, again, next page you'll also see what is the next page you'll also another line, my lord. And next page very interesting, my lord. You'll also see this court here also directs in the event the petitioner is holding a non-sanctioned post, steps may be taken in sanctioning the post, keeping the long continuance.
And in 614 of 2020.
My lord.
Next sub-item. Next sub-item.
All these matters same direction, my lord. My lord.
Not in same. My matter, my lord, 1466 of 22. Maybe in the next page. This starts with 22, 1483.
614 is not.
Sorry, my lord, for a moment, my lord, because all my files are.
614, in that view of the matter, this court disposes of this writ petition directing the opposite parties to consider the case of the petitioner and regularize.
And regularize. There is a direction and regularize. Everywhere there is a direction, my lord.
So that to consider will not be a common factor.
If there is a direction
To consider the case of the petitioner and to consider regularization.
yes, but that two aspects are there. If there is a direction to consider, then we will consider in accordance with the resolution and also the judgment of the Honorable Apex Court, whether it is entitled for regulation or not. But here is a direction to consider and regularize.
then there is no option for us than to regularize, except than to regularize.
What is this contingent paid worker? Contingent paid worker.
They are paid from contingency. So they are contingent paid employees.
Yes, we are prima facie satisfied.
No, my matter is next page. This is not my matter. My matter is 1466. What is next page? This is not item number 83. Eh? Serial 83. That's in fact I was praying for a day to
What is the number?
1466 of 22.
1466.
Yes, my lord.
Also decided on the same day.
All the matters.
Same day. Regarding that, my lord.
All the matters in the same day.
Your lordship, I am 99 counter. Today it is for condonation of delay. I have filed already counter. Counter must not have come. If your lordship would kindly permit, I have got Xerox copy what I have filed. I am just giving before your lordship, and I may be permitted to place it before your lordship. If your lordship receives it, then my lord, this is the counter to the condonation petition. Everything I have stated here. That my lord, that your lordship may kindly see, my lord, if this is a case where the stay has been granted without condoning delay in my item. Stay has.
All right, that has been done, but we are going to dispose of the writ of the.
Yes, yes.
That order you could have challenged, but you could have sought withdrawal, recall of the order.
That I have filed a contempt application. That your lordship may kindly appreciate one thing.
Council, according to you, stay order has been granted by this court without condoning the delay.
Yes, that I am bringing to my lord's kind consideration, but I would address your lordship on merit.
Then
Yes.
why are you
Yes,
speaking that?
yes, yes, my lord.
So how is that relevant
No, not relevant.
for us?
It's not relevant, not relevant. Then regarding condonation, if your lordship, I will address your lordship. One thing I may bring to your lordship, my learned friend submission is pertaining to merit. Recently, my lord, yesterday I got a recent decision of Honorable Supreme Court. Having summarized the earlier points, my lord, and that merit cannot is not required to be gone into highly considering petition or condonation of delay with more than 1 year delay. Regarding delay, I have stated before your lordship, my lord, they took the responsibility to themselves, my lord. My lord, interpret the order passed by the Honorable Court, passed a contrary order. What will be the fate of the contrary order? That is a void order.
When was the order of this court passed?
Yes. Order passed on 16/4/2021.
No, this my matter is 6/7/21.
Case paper.
Past case.
6/7/2021.
16/4/2000. No, first.
Your case,
My case 6/7/21.
6/7/2021.
Yes.
And whether the COVID situation was there or not. in your
My lord.
case.
My lord, COVID period was there.
COVID period.
Yes.
Whether the order of the Supreme Court has to be taken into account or not. Some period has to be excluded.
Up to 22.
Acres of 1/6.
Up to 22. That's right. That's right. But what I beg to submit, your lordship may kindly appreciate the conduct. Within 2 minutes, I would just submit it for lordship would kindly permit. My lord, when the order is passed in the office, my lord, by sitting in the office, without complying with the order, my lord, they rejected passed the contrary order to the direction of this honorable court. Apart from the fact,
These are the order of contempt.
contempt I have filed, they have also admitted.
That can be.
Saying the contempt application,
Mr. Counsel, we are at present considering the legality of the order. That's all.
That's,
Whether the order can be sustained or not. That's all.
that's,
The order cannot be sustained. The order can be sustained, it's all right. The order cannot be sustained. Still, you may have a claim that interim order was violated, therefore.
your lordship knows one position of law, natural justice is not an empty formality. Even if they would have been noticed,
At least you have.
what possible difference they would have said.
Let us to know this law.
What possible difference they have disclosed, because advance copy was given and having heard the state council order was passed, they did not pay to the honorable single judge for granting time to obtain instruction. Thereafter, my lord, 3 courses open, but they did not file. So the writ appeal on the ground of delay, if your lordship would consider more than 1 year, it is up to my lords. Well, poor daily rated workers, my lord, gets 300 rupees per day, and their regularization having worked for 22 years has been sought.
We know the people who don't get even a single fine a day.
Yes, yes, yes.
So you are claiming regularization.
Can it be possible, Lord? 30th, 2 o'clock. Right. But the interim order is there, both sides. Now, also want to continue.
With the party. Matter is adjourned. Taken up and.
Great.
Smaller cell phone, given the need.
Right. Item number 18. Next, resolution. Next, sir, one is the input order. Last, come to page 12. On earlier occasion, you have heard this matter. This is a matter relating to that. You also may remember that 25 FA. Termination was made and payment was made 1 day after.
Is it 688?
Sorry.
Is it 688?
Yes, yes, matter.
Which order is this?
Yeah, that's page 12, my
17.8.
my lord.
My lord, I am for the respondent. Already argument was over on that day on 10th of this month, my lord. Only my lord asked the state appellant whether any judgment is there to produce before this court. If 1 day delay is there, then it will be not treated as a violation of that law. That is the point, my lord. Already argument was over. My senior as Mr. Gautam Acharya have already appeared in this matter and argued the matter. Although state have already argued the matter, only point was that my lord has asked the state appellant, if any judgment is there, is 1 day delay is there, then 25 of ID Act will be applicable or not. If my state appellant is collecting any judgment, yes,
All right, let him complete.
my lord.
May I read my estimate page 30, my lord.
13.
30, my lord, para 12.
In view of such position, the contention raised by Mr. M.K. Mohanty and counsel for the petition that the order of retrenchment dated 29/4/2011 under Annex 10 and payment of wages in lieu of 1 month's notice of which was offered on 30/4/2011 under Annex 11 being not simultaneously one cannot be construed as full compliance of Section 25(a) of the Act, yet ample corroboration from the materials available on record and such as sufficient force. Thereby, in view of the proposition of law laid down by the apex court, discussed above, this court holds that the imposed order of retrenchment cannot be allowed to stand since there was sheer violation of the provisions contained under Section 25(a) of the Act. So far as non-compliance of the provision contained in Section 25(g) of the Act is concerned, admittedly the petition was engaged on 25/3/1985 as a member made under the Executive Engineer Mahanadi Barrett Division, Cuttack. Though she was retained from service on 1/3/89 by virtue of the award dated 24/2010 passed by the Industrial Tribunal in ID case number 256 of 2008, she was reinstated in service with 50% back wages. In the meantime, in terms of the regulation passed by the government, some of the juniors were brought to the work charge establishing discriminate the petitioner, though she has continued. Thereafter, the superintending engineer by letter dated 30th September 2010 intimated the engineer that juniors were continuing in service without considering the same, the order of retrenchment were passed in Annex 10 dated 29/4/2011 on the basis of instruction issued by the government on the ground that due to reduction of workload her retrenchment to the expedient. In that case, the provision contained under Section 25(g) were to be followed scrupulously, meaning thereby the junior most person had to go, allowing the senior to continue. So the petitioner had been appointed prior to 12/4/93, and she was senior most MMR. She had to brought over to the work charge establishment and subsequently to the regular establishment instead of directing her to face retrenchment due to reduction of workload. Thereby, the provisions contained under Section 25(g) have not been complied with. Consequently, on that count, also the order of retrenchment under Annex 10 dated 29/4/2011 is contrary to the provisions of the Industrial Dispute Act 1947. These views get ample support from the judgment of the Honorable Apex Court in the in charge government High Center and Gauri Shankar mentioned Sutra. In view of the factual metrics and proposition of law discussed above, this court is of the considered view that the order dated 29/4/2011 in Annex 10 retrenching the petitioner from service with immediate effect cannot sustain in the eye of law, and the same as in past without complying the provisions contained under Section 25(a) and 25(g) of the Industrial Dispute Act 1947. Consequently, the order dated 29/4/2011 in Annex 10 is liable to be quashed and hereby quashed. Proposed parties are directed to reinstate the petitioner in service and to bring over to the work charge establishment for to it from the date our juniors have been brought over to the work charge establishment in pursuance of the notification dated 58/2009 and 19/6/2009 issued by the government, and then bring her to regular establishment for which if the juniors have been brought over to the regular establishment. Further, keeping in view the fact the petitioner has been retained without following the prescribed procedure, and as such the fault lies with the employer for such illegal retrenchment, also being aware of the fact that petitioner has not discharged her duty since 29/4/2011. This court directs the opposite party to pay 50% wages to the petitioner with effect from 29/4/2011. Till she is reinstated in service. I have telling you the three grounds. First ground, the rate is not maintainable in view of the provision laid down under ID Act. He should have approached the Industrial Tribunal if he has a grievance of violation of Section 25 of the ID Act.
He should have approached.
No, he has not approached.
No, he should have approached.
Industrial Tribunal, my lord. Instead of challenging here in the Real Court.
No, the matter was before the Industrial Tribunal only.
No, my lord, that I will explain, my lord. What has happened, my lord? The matter was earlier before the Industrial Tribunal. We will also make my lord's notice to the read petition. We will also see the read petition annexure 1.
No, but in any case, since the writ petition was filed in 2004 or something, And the matter was taken up on in 2000.
My matter, petition was filed in 2000.
2013, and the matter was taken up more than 7 years thereafter.
On the ground,
It would have not been proper for the High Court to.
that's why one ground, my lord, the rate is not maintainable. Second ground, my lord, the admitted facts is a DLR employee. If, well, for any reason, it is found that his termination is in violation of 25A, so reinstatement is not automatic. On that occasion, your lordship had directed me to give a judgment so that whether reinstatement is automatic or not, and relying two judgments, my lord. In such cases, if that termination is found there is a procedural defect, then what would be the consequence, my lord? Two 2014 7 SCC 177.
Well, the only question now I remember was that if there is delay of 1 day or 2 days.
Yes, my lord.
Then whether that retrenchment can take effect from that day or not.
Yes, my lord.
Yes, my lord.
Your lordship has,
Yes, please let him argue.
your lordship has seen that retrenchment letter and the compensation just thereafter. So on, because that was paid later on, it was not simultaneously. Your lordship has held that it is in violation of 25A, 25GFA. My contention before my lords, if this is a procedural or latches, and for procedural latches, the termination is declared invalid, what would be the consequence? That is the judgment I have delayed.
What is that?
That your lordship has see para 33, 30, 34 and 36 of that judgment 2014 R 7 SCC page 177. It starts from paragraph 28.
In para 33, my lord. This is the ratio decision. And moreover, our ground, you'll also see ground H of my writ of appeal. That when his seniors are continuing and has not been brought about to the work charge establishment, direction for to bring him the work charge establishment is also not permissible.
So his junior was continuing.
Yes, my lord, that will also see paragraph H, ground H of my writ of appeal, my lord. Page 8 of my writ of appeal, my lord.
Yes.
That's got it. Yes. On the other hand, the following incumbents were continuing before the appointment of the person have not been brought about to the work charge established till date. And he has filed a response to this writ appeal, he has not objected it.
No, this is different.
Sorry, ma'am.
If the writ petitioner says that his juniors,
Well, I have seen that.
and you are saying that his seniors were not brought in the.
Yes, ma'am. I am submitting to that extent. What has happened in regular course, seniors have not been brought about to the work charge establishment. In some cases, what has happened, my lord, in court orders are there. While implementing the court's order, sometimes some juniors are brought about to the work charge establishment. And in all fairness, my lord, we will also gone through the judgment, my lord. If admitted that retrenchment is in violation of the 25, that's the procedural defect, because admitted fact he has been retrenched and the compensation has been paid just 1 day after. This is the admitted fact, I cannot dispute it. If this is a procedural defect, my lord, then a compensation can be granted to me in view of that honorable apex court judgment, my lord. But reinstatement with back wages is not automatic.
So how much compensation?
I cannot. You'll ask me to decide this is my submission before my lord.
Yes, how much compensation, Mr. Counsel?
No, I have to take a issue because in this matter, my lord, what happened? 1 day delay is there, and there is no proper explanation of that delay. And 1 day delay also, that means the violation of that provision of that act, my lord. And again, my lord, page number 34, kind glance of my objection, my lord. Page number 34.
Objection to?
Objection to the writ appeal. Objection filed by the respondent.
What?
Counter, yes. 34, page number.
Yes.
Accordingly, taking into account the date of engagement of Srimati Mahanti on dated 21st March 1985, it is observed that number of workmen in the category of NMR are met are continuing in service who are junior to this Srimati Mahanti. It is the letter of Superintendent of Engineer, Dene Circle, my lord. When retrench order was passed, Superintendent of Engineer said to the executive, to the engineering chief, how it is possible where junior is continuing? It is their letter. And again, my lord, what happened when they reinstate my client?
Even the senior most can be retrenched.
No, my page number 25, my lord, of a glance, because when I reinstate my client, there
You
it is.
don't have any right to continue.
Yes, my lord. Because in that reinstate order itself, they write that reintrench him accordingly. Page number 25, my lord. Issued by Additional Secretary Government.
See, for retrenchment, in fact, no action is required, just compliance of section 25F.
Yes, that is not compliant, my lord.
That we will examine. What is
Yes.
the effect of that
Yes.
non-compliance?
Yes, that is the page number 38, my objection.
Please discuss on Monday. Monday to water spectrum. So that's.
My lord, can it be granted urgent to after 27 so that my senior can argue the matter? Already argument was over.
No. You not pay for it for the effect.
Pardon to
My lord, my associate is there. I want to submit one judgment also. My associate is there, he will submit.
Give your judgment. Who has stopped?
No, my lord.
I need to pardon me, lord. Item number 13, last item number PIL 8763. You kindly release from the Abdas cases. That matter is 2020 and 2023. Mine one is only 24 minutes, and 3 times I tried to make your lordships convinced that I am perhaps not able to. That is a fresh matter, and I will have after notice. And after their counter, there are so many legender counter, so many weeks out. We have a simple thing. They may kindly permitted to place the matter before the lordship the authority. How it is helpful to JICA and municipality to make the city clean and
You shall be at liberty to make all those submissions before an appropriate bench,
Yes.
which is going to be constituted for this purpose. All right.
Yes, I will be permitted to make a mention. The lawsuits have been pleased to your direct personal appearance of the officer in item number 29 for non-compliance. In the meantime, I filed the compliance evidence since you have complied with the order,
All right.
passed a judgment, and pursuant to that, the petitioner has joined our service also. Explain the director and the president and the both are present.
All right. So for the future,
Yeah.
you must keep in mind
Yeah.
that when personal appearance of any officer has been directed,
Yes.
you can make a mention in the morning
Right.
so that he may not have to wait in the
Right,
courtroom,
I'm highlighting.
and that matter can be taken upon priority basis.
This is not right.
The only thing which you are required to do is to inform the other side.
Right, no.
All right.
Yes.
So, all right. Which matter?
Item number 25 was contempt 406 of 2024.
29. Pursuant to this court's order, the director,
The secondary education.
secondary
I
education,
also.
so and so is personally present. Stop. Have you tendered Apology.
Yes, the pretender apology.
He has tendered unqualified apology for non-compliance of this court's order, violation of which has been alleged in the present application. So far, Procedural has, however, informed this court that the said order of this court has been fully complied with. Learned counsel for the petitioner agrees that this court's order has been complied with. Considering the subsequent conduct of the contender, his unconditional apology, the unconditional apology tendered by him is accepted. The present contempt proceeding stands stopped.
Lord, item number 30, last item, Lord, in the list. That is it, Lord, tender matter, contempt application has been filed. This honorable court has quashed the tender of the successful bidder and directed that I should be considered. Lord, that tender PL is going to, what will I do? The Lordship may kindly take up this matter Monday.
He'll come on Monday.
My lord, item 25, your lordship. Item 25, there is a matter, your
We
lordship.
don't go back generally, but yes, since you are mentioning what happened.
I only pray that let it come on Monday because the admission process starts on.
Come on Monday.
It's a partition date. The arbitration clause by Lord would see at page 16, clause 21.
All formalities complied with,
Yes, sir.
issue notice. Yes.
Grateful.
Item number 2.
May I please, your lordship. The agreements are in NSR 1 and the arbitration clause is also there in 20 and 18, your lordship.
Issue notice.
Item number 3.
Item 3, I pray for an adjournment.
Lord, I three people of I am appearing for the opposite party, my lord. My lord, may see the IA itself, the prayer may not be maintainable before your lordship because what he desires now is under section 11 to seek for change of the arbitrator, my lord. So, my lord, what I was saying, once this honorable court has appointed the arbitrator, the arbitration proceedings are continuing. Now, praying for a change of the arbitrator may not come under the scope of section 11 is my submission, my lord. Because for that, a similar
That will come under which provision?
14, what I believe, my lord, section 14. And earlier, a similar application was filed after the 11.6 was disposed of by this honorable court. That has been dismissed already, long back. Now, again, another application is filed now for change of the arbitrator in a disposed of case, my lord. First of all, my lord, this IA itself may not be maintainable because this being a disposed of case, IA, my lord, is per se not maintainable. Again, a prayer for change of arbitrator after appointment under section 11. For that, my lord, my humble submission would be, even if he wants to challenge the mandate, that would come in the purview of section 14. For that, he would be required to go to the competent court.
Milan, conducting counsel, Mr. Equivalency is not well. Conducting counsel, Mr. Equivalency is not well. He's admitted for heart stenting.
Position of current counsel for the petitioner lists this matter on 1 week.
Item number 4.
Item number 4 and 5, your lordship. On order dated 5/4/2024, I was directed to file the requisites. I filed the requisites, but in a delayed manner. Those may be accepted.
It is stated. No, but earlier also, when was the order issued? The order passed.
For filing of fresh requisites, the order was passed on 5th April 2024. I was directed to file the same within a week. I filed it on 16th April.
Current counsel appearing on behalf of the petitioner states that pursuant to the order of this court dated 5/4/2024, requisites have been filed, though belatedly, on
16th of April.
16th April 2024. Stop. Considering the facts and circumstances, time granted by the court order dated 5/4/2024 for filing the requisites is hereby extended to 16.
Yes, Lord.
16/4/2024. So stop. Let the registry take steps based on steps for issuance of.
Much obligation.
Item number 6.
Not leave last ones. Going to the petition minutes. Once, item number 7 may be taken up first. The minutes. Item 7, that is 22 of 23
They are
minutes.
connected matter.
Some of them all are connected. 6, 7, 8 are connected minutes. Item 7 minutes. So matter is also work contract. That's after completion of the project, that is a cycling building of cycling center by the authority. So we are handing over to the authority after meeting, and the vote and final bill is still yet to be paid minutes. Dispute arising of that, and after giving several recommendations also, they are also admitted that some of this pending, and somehow or the other they are not responding now minutes. After my admitted notice, and they have responded minutes, and the mutual consent. 16:1, the arbitrator has been already appointed, and after being appointed minutes, they have withdrawn. Again, minutes, no, that's the procedure not been followed, and but as for the law, that's why we are withdrawn, and we start at risk. But after mutual, it has been decided, the arbitrator list prepared by the Supreme Court, and we have given the consent. They are asking for consent. We have agreed. And now they are withdrawing it for us. So that everyone has to find this minus 11.6. Otherwise, it was already done. Actually, the arbitrator that list of arbitrators which cover High Court matters. Lords, I'm appealing for the Orissa State Disaster Management Authority, Lordship. Lords, in fact, the letter of withdrawal was sent because of two specific reasons, Your Lordship. First is that, Lords, the when they recommend the names of the arbitrators to us, instead of giving us the whole panel list of arbitrators, only 3 arbitrators were provided, names of only 3 arbitrators were provided to us, Your Lordship.
By whom?
By the petition, by the claimant, Lords. But as per the rule 9 of the internal management rules of the arbitration center, which it states, if I may place, Your Lordship, rule 9(3), Lords. A curriculum writing shall be furnished by the persons interested to be placed in the High Court of Orissa panel of arbitrators in the form prescribed in Schedule 5 of the High Court of Orissa Arbitration Center rules. Information so submitted by the persons who are finally empaneled may be made available to the parties seeking to appoint an arbitrator from the panel and request. The parties may choose any person from the panel to be appointed as arbitrators.
Panel also.
Yes.
From that panel, they had selected 3. You are saying that they should have provided you the entire panel.
What's the impression that they received is that they have to choose between these 3 arbitrators.
You could have suggested 3 other names other than what was supplied by him to you.
That's good.
Not that they are required to. They suggested 3 names out of the names from the panel. You could have. That is not a ground.
And also, the second phase of my argument is that in action, Look, sir, as per the GCC clause to 25.3 lakhs, if there is a failure on selection of the arbitrator, because the same is to be said before the President of Institutes of Engineers India, who will act as the appointing authority in election. As per 25.3 lakhs. And
That has been held to be illegal.
remarks.
That clause cannot be implemented to.
Look, in fact, I was verifying also there were conflicting judgments on that also.
No conflicting judgment. The issue has been resolved.
So I try to satisfy your lordship by granting one opportunity next week, because just now I came across a judgment in which is stated that in the arbitration contract, I mean the contract, if there is a clause which specifies on how the arbitrator is to be selected, then that has to be followed, your lordship.
If the person who has to select an arbitrator
Lordship.
has interest in subject matter, then that is not permissible.
Lordship, but
That is the Supreme Court's decision.
yes, these are like ground statements. I prefer one particular lordship.
I am adjourning for next Friday.
My lords.
And on next Friday, you come with specific name. All of you, both of you agree.
Yes, I don't have an objection to that, what my learned friend is saying. One thing I'd like to point out to my lord, what my learned friend was saying, annexure 13, my lords. The entire panel was before them. One of my annexure 13 to 120. It's not
No, it's entire panel.
itself. It's their letter. With reference to subject side of that, I have say very
Small,
yes, it's their letter. I only try to satisfy lordship.
Requested on behalf of what you are called opposite party.
It was also the response to it. It was called member to the village.
Let this matter
One.
1 week.
Sorry, lordship, for the response, one.
That parties shall reach consensus on the names of the one arbitrator or more.
One arbitrator, one.
The name of the arbitrator to be appointed under section 11, bracket 6 of the Act.
Open lordship, commissioner, suggest one name, now itself be clearly.
No, this is outside the court. Outside the court, you away. Just come with a name.
6, 7, 8 similar matters.
6, 7.
9 matters. The case is even one.
Let the matter be.
9. Oh, sorry. 6, 7, 8, 10. 9 matters is even worse matters. Already name has been listed and arbitration or question is going on. We have filed already a claim statement before the arbitrator. Then the arbitrator would be himself. Then we file an application number 15, which is for substitution my lord knows. 15. They do not respond to it, my lords. And then I have to come with them, my lords. Already the arbitration procedure is going on. Then some reason or other, they will go on. And 15. We are little bit done substitution, and there's no other reason. Then I have to come with my lordships, my lords. Lords, I've already taken my learned serious concern, your lordship. Lords, I have to go. I received the brief yesterday only, my lords. I will let it come along with the other matters. I will.
I requested on behalf of the respondent, let this matter on 1 week.
Next Friday matters.
Next.
Include less minutes.
Item number 10.
Any lordship on behalf of Mr. P.K. Parry, who is out of station. Madam, can you take the
In
next?
9, there are so many matters. 9 is a match up.
My lords, 9, that's my lords.
9. It is these matters.
That is 9 only, my lords. Right. Item number 10.
For next week, on the Mr. P.K. Parry, who is out of station. Madam, we're disposing to matter next week, sir.
This matter, your lordship, had on the last occasion, I think why I'm going to come with names.
This matter. That's why
These are petty matters.
Next week.
On behalf of your respondent.
Yes, okay, respondent 1 to 2.
Matters. List this matter on next Friday. Yes.
Special list. Item number 1,
ABLA PL 1719 of 2020.
May it please.
So, my petitioner is the lady, woman, my lord, the owner of the vehicle. And she has been obligated under section 3A of RP and section 153 of the Railway Act, madam. Though her name was not restricted, but since she is the owner of the vehicle, that why she is apprehending arrest and.
But why anticipatory bail? A regular bail can be granted, but not anticipatory bail in such matters.
Offenses are minor, magistrate, tribal by magistrate. Offenses are tribal by magistrate within 7 years.
So therefore, raise the question of anticipatory bail in such matters. This is what the court is objecting.
The owner of the vehicle and a woman, actually. Owner of
Woman.
woman.
She is a woman
Yes, madam.
and she is indulging in such. The petitioner is a lady who is owner of a Mahindra Bolero, registered owner of Mahindra Bolero pickup van. First off, it is the prosecution's case that in course of conduct, in course of a raid conducted on 8/2/2024, the RPF personnel apprehended someone who was absconding in connection with RPF post Bhadrak case number 18 of in connection with this case, connection with the aforesaid criminal case. Stop. A PN was it is further alleged that the person so apprehended confessed his involvement in commission of theft of railway property during the course of investigation, during the interrogation by the RPF people. Stop. The said vehicle was found laden with 40 number of white color plastic bags filled with imported coal, and each bag containing 25 kg of coal. Stop. Next, learned counsel appearing on behalf of the petitioner has submitted that the petitioner's involvement is mainly on the basis of confessional statement of co-accused made before the RPF personnel. First off, he secondly submits that her implication is in the criminal case is mainly because of the fact that she is the registered owner of the said Bolero vehicle. Stop. Next. Antecedent?
No.
He has also submitted that the petitioner has no criminal antecedent. Stop. Considering the facts noted above, including the fact that the petitioner is a lady, in my opinion, a case is made out for grant of anticipatory bail. This application is accordingly allowed. Yes.
I am appearing for the opinion.
Any objections?
Objection. Objection is already. None may be recommended. And none may be recommended. Item number 2.
A pagulars. The petition has been implicated under section 447, 379 by 34 IPC Mallet. Allegation is that while the informant and their staffs were performing patrolling duty, got information regarding transportation of laterite stone by a tipper Mallet. And by seeing the police personnel, the driver of the tipper along with some other personnel who are working. You are the owner of the vehicle. Here, my lord, I am a owner of the vehicle, and that vehicle also not another owner has been released on bail by your lordship. That is ABLFL. That is in the. Yes. How do you distinguish his case?
My lord, I have not got the annexure to. My learned friend is claiming that he is the owner and saying that another owner has been released on bail. Your lordship may consider.
So how yes, learned counsel appearing on behalf of the petitioner has drawn the court's attention to an order dated 11/3/2023 passed in APL number 2043 of 2024, whereby co-accused Ranjan Kumar Subudhi and your lordship has granted only owner to the owner of the vehicle. Ranjan Kumar Subudhi, yes, my lord, has been granted privilege of anticipatory bail in connection with the same criminal case. Same criminal case? Yes, same criminal case. The office submits that the petitioner's case cannot be distinguished from the case of said Ranjan Kumar Subudhi. So, learned counsel, learned that is your public prosecutor. Learned public prosecutor has not been able to distinguish the petitioner's case with that of co-accused Ranjan Kumar Subudhi has been given privilege of anticipatory bail. So, in such circumstance, this application is allowed. Yes.
Item number 3. Made Your lordships. Your lordships petition is in custody since 12/1/2024. But the offence alleges lordships 457, 395, 25 and 27 of the Arms Act lordships. And your lordships allegation lordships 7 to 8 persons entered into a electrical project area and assaulted the security guard and looted some copper wire and forcibly copper wire from the 50 kg copper male female part of fuse and lordships from the forcibly took a gold locket, ring, cash, ATM, DLRC vehicle of that security guard lordships.
And also similar circumstances, lordships are, and the receipt of the conflictual statement of the petitioners, lordship, they have been arranged by accused lordships. And lordship, one of the co-accused named lordships, Bimal Mahalik, who has been arrested. And based upon his statement, lordships, this petition name has been implicated. And he has been released on bail by the court below. And under similar circumstances, lordships also granted bail once Nandu alias Satya Prakash Naik. This is the order, lordships.
Yes,
Yes, I have seen one accused person has been granted bail by this
it
and
is submitted on behalf of the.
the
It is submitted on behalf of the petitioner that similarly circumstanced co-accused Nandu alias Satya Prakash Naik has been directed to be released on bail by an order dated 5/4/2024 passed in BLA PL number 1774 of 2024. First off, a copy of the said order has been produced before this court by Joint Counsel for the petitioner. Learned public prosecutor has not been able to distinguish the petitioner's case with that of co-accused Nandu alias Satya Prakash Naik. First off, in such view of the matter, this application is allowed.
No joke.
Item number 4.
Net loss. Flag even under kind of evidence. The lordship granted bail to one of the co-accused standing in similar footing. Here though 20B2C is there, but so far the petitioner is concerned and the person who was granted bail by your lordship, 3 kg of contraband ganja was seized from them. Total 34, 5 active persons are there. As per the prosecution case, from one Kartik Hazara, 22 kg was seized, and so far the other 4 active persons, each persons have been attributed in possession of 3 kg of ganja. The lordship granted bail to one of the accused.
So from your position, how much was it?
3 kg standing in similar footing. Page 12 kind of ones. Page 12 of the authority. What is at the middle? After weighment of the ganja of all suspects of the quantum ganja was again kept separately in transparent polythene packets. The ganja was the smell. Same. This is the order.
Can you give a glance to rejection order?
Huh?
Rejection order, that is page 18. 1/8.
Page 18.
My lord. The quantity of ganja seized from accused persons named so and so, including the present petitioner, Sharmila Kumar Bhui, are found to be 20.
No, that was from all the persons. From his person.
Some 3 kg. There, my lord, 3 kg. Each 3 kg total, grand total 22 kg. That is my assumption.
It has been submitted on behalf of the petitioner that from the petitioner's possession, only 3 kg of ganja was recovered. First off, this court in similar circumstance in the present case has allowed an application for release of co-accused on bail in co-accused Tulasi Sasmal on bail by an order dated 27/3/2024 passed in BLA PL number 2560 of 2024. So after having perused the court's order dated 27/3/2024 passed in BLA PL number 2560 of 2024, I find substance in the submission made on behalf of the petitioner that the petitioner's case is on similar footing. First of all, public prosecutor has not been able to distinguish the petitioner's case with that of co-accused Tulasi Sasmal for the purpose of exercise of discretion for grant of regular bail. Stop this application is accordingly allowed. Item number 5.
No, please, Your Lordships. Your Lordships, this is a case under section 326, 307 and other allied offences. The present petitioner is the main assailant of this case, Your Lordships. Your Lordships has granted bail to the co-accused persons and allegation of assault by Bhojali aiming towards the thighs is there, Your Lordships. The injuries are grievous in nature.
So you should not press it.
Lordships,
So you are the main person.
Your Lordships.
So seek regular bail. Come.
Your Lordships is in custody since custody since Your Lordship 6/12/2023, being taken on remand. Lordships, in this case, it's a case under section 326 of IPC 307 is not being attracted, and any allegation of taking over the life is not there in the affair, Your Lordships.
Let us see.
My lord, case diary is not there. Can you do last page number 30?
Five, yeah. 3429. Which item is which case number is this?
Your Lordships has BLFPL 3429.
3429. Yes, what is the allegation?
Allegation is that, Your Lordship, the accused persons came to the house of the informant and threw a piece of stone. When the brother of the informant, hearing such halla, came outside and asked about such deeds, all of a sudden the accused persons coupled his brother and attacked his brother by means of a bhujali aiming towards his thighs and private parts, Your Lordship.
No.
Lordship, the main facilitators of this case has already been granted bail by Your Lordships.
Facilitators have been granted bail.
And charge sheet has also been submitted, Your Lordships, in this case.
Sorry.
Lord, what has been discharged. Another thing is that this person is also involved in a case under section 302 of IPC. That is that, page 13, paragraph 3.
Upon perusal of the first information report, I find that there is specific allegation against the petitioner of having assaulted the victim with a heavy sharp cutting weapon in his thighs and private parts. First of all, counsel for the petitioner has attempted to convince this court that no offense under section 307 of the IPC is made out. First of all, made out on the basis of what has been alleged in the FIR. Stop. I am not inclined to accept the said submission. Stop. Considering the gravity of the accusation against the petitioner, this application is dismissed for the present. Stop. The petitioner's prayer for his release on bail is rejected for the present. The petitioner shall, however, be at liberty to renew his prayer for bail after 6 months, if in the meanwhile charge is not framed. Yes.
Item number 6.
Here also my lord, section 3 of the RPP Act and 153 of the Labour Act. Last provision, my lord, was an order directed by 41 notice must be issued.
Now, here what happened, no, 41A notice has been issued. Here now he is a habitual offender, and except this case, two other cases are there. In one case, similar type of offences are there, and in one case he has been convicted, in another case trial is going on. And moreover, one of the clerk process bail, anticipatory bail application is,
Anticipatory you may withdraw, otherwise you will have to.
and will also reject one of the clerk bail application.
Otherwise, any observation made by this court will learn counsel for the petitioner after some argument. Submits that he withdraws this application. This application is accordingly dismissed as withdrawn. First of all, it is made clear that withdrawal of the present anticipatory bail application shall not prejudice the petitioner's case while considering his claim for grant of regular bail. If he surrenders before the court within 8 weeks and applies for regular bail.
My lord, item number 7.
In this case, my lord, my order dated 5/4/2024, the lordship call for the case daily. My lord, in this case, I have not received call. Yes, well, and wait for 1 week time to receive the same.
As requested on behalf of the public prosecutor, list this matter on 1 week.
Item number 8.
Next Friday, next Friday,
Next Friday, as requested on behalf of the petitioner.
public.
That was item number 7. Number 8 is. Item number 8.
Item number 7 next Friday, yes.
Yes,
Item number 8.
8.
modification and then
There is no representation on behalf of the petitioner. List this matter on 1 week.
Item number 9.
My lord, on behalf of this, my lord, 2 hours have been called for extension and for extension of time, my lord. My lord, order dated 20/2024 at para 7, my lord. It has been wrongly typed as JMFC instead of JMFC to district Malkanagiri. This is the prayer, my lord.
Yes.
Para 7.
What do you want? What for?
One for modification, my lord. Modification. At para 7 order dated 28/2024. Instead of my lord, JMFC note, it has been wrongly typed as JMFC Khurda, my lord.
MFC?
Khurda. Wrongly typed as JMFC Khurda.
So what should happen?
So the Honorable JMFC court is not accepting this order, my lord. So for this doesn't
Which is the correct court?
JMFC note. District, my lord. JMFC note, district Malkanagiri, my lord.
The petitioner was allowed anticipatory bail by an order dated 28/2024, passed in APL number 1639 of 2024. Stop. He is an accused in GR number 598 of 2023 arising out of Motu PS case number 148 of 2023, which is pending in the Court of Learned JMFC Motu. Stop. While granting the petitioner privilege of anticipatory bail, JMFC Khurda has been typed in the said order dated 28/2/2024 in place of JMFC Motu. Stop. This court's order dated 28/2/2024 shall be read accordingly. Stop. JMFC Khurda in paragraph 7 of the said order shall be read as JMFC Motu. Stop. IA's number 682 of 2024 and 667 of 2024 stand disposed of.
Extension of time to
The time allowed to the petitioner to surrender to appear before the court below as directed under the order dated 28/2/2024 is hereby extended to 2 weeks from today.
3 weeks.
3 weeks from today. Item number 10.
May I please illustrate my matters? Here in this revision application matter, it present
You are the petitioner.
what petition.
There are 2 cases. There are 2 cases. In one case, I am there petitioner. And the other case.
So what is the solution? This is of 1997.
Yes, ma'am.
What is the conviction?
Condition is 395. But okay, I have prepared a short date chart. If you also to kindly peruse it, only on the basis of the TI period conviction, minus corroboration. There is no corroboration. It is with regard to merit. With regard to sentence, they have undergone some period, 2 years, 3 years like that. It can be period undergone by interfering in the sentence because it says that it may extend to 10 years. That's why, my lord, it is awarded 5 years only. Trial court and appellate court, 5 years. Out of their 5 years, some period must have been undergone.
95.
395. I please, man.
396 life and up to 10 years. Life,
Oh,
first life.
life has not been awarded.
No, no.
What is awarded?
Permissible.
Yes, let us see the appellate court's order. Where is the order?
If you also permit me, I will place some. If you also allow me, I will place some on what is about the unmarried matter.
There are 2 revision applications.
Two revision application. For 2 petitioners, I am for 1 petition.
So
Single.
let us see the appellate order.
Well, at that I am placing my lord. You will also allow me. So for trial court is concerned, my lord, the trial court convicted 4 accused persons under section 394 and the sentence for 5 years, my lord, on the basis of identification and recovery of goods, my lord. So for appellate court is concerned, my lord, the appellate court acquitted 1 accused person on the ground that nothing whispered against him by the witnesses, my lord. Proceed kindly turn to page 7 of the appellate court order. The Lord appellate court disbelieved the identification, my lord. Proceed kindly into page 7 plus 8 lines from the bottom, my lord. PW2 has admitted in her evidence My place, no.
Paragraph?
Paragraph that is page 7, my lord, that paragraph starts from 7 paragraph, that starts from page 6, and that is page 7 I am pasting, my lord. That 8 lines from the bottom, my lord. PW2. PW2 has admitted in her evidence. As you got it, I will place.
Page 7.
Page 7. Page 7. Appellate court judgment, my lord. Internal page 7, my lord. That is.
Yeah, I'm seeing the appellate court judgment.
Paragraph.
Paragraph 6 strategy 7.
Page 7.
Page 7, my lord. That's PW2 has admitted in her evidence that these 3 appellants were brought to her house.
Send which line? Which line?
8 lines from bottom, my lord.
8 lines from the bottom. TI parade held about 2 months after the occurrence. PW2 admitted.
No, my lord. PW2 has admitted in her evidence that these 3 appellants were brought to her house by the police after 1 month of the occurrence. So it cannot be altogether ruled out that the police had shown these appellants to the witnesses, and accordingly the witnesses have identified them in TI parade as well as in the court. Since the witnesses had the opportunity to see the appellants before identification parade was held, the TI parade loses sanctity. It would also be risky to place implicate reliance on their identification in court after 1 year of the occurrence, as the witnesses were not expected to mark and remember their physical features at the time of commission of dacoity, particularly when they were wearing masks and on their face and topis on their head. Therefore, in my view, no reliance should be placed on TI parade as well as on the identification of in the court, and on such identification, it cannot be reasonably concluded that the appellants were actually present among the culprits committing dacoity in the house of PW1 during the midnight night. The trial court appears to have been committed an error in placing reliance on the identification in TI parade and identification in the court at the time of hearing of the case. So far, the Lion court considered about the TI parade and disbelieved the same. So far, my 2 petitioners are concerned, my lord. Proceed kindly turn to page 10, my lord. That is paragraph 9, page 10, my lord. It starts from on 4 page 94. Page 10, my lord, paragraph 9, my lord. Those are my paragraph. On 4/4/94, appeal number that is petitioner 2, being in custody with the PW3 to house in village Contagao, and gave recovery of one green and yellow color cotton saree which was seized by PW13 under seizure list exhibit 8 in presence of PW10. That was also appellant brother, that is petitioner 1, being under arrest, led the PW3 to his house in village Bandhavendura and gave recovery of one light violet color saree from his house. And the same was seized by PW13 as per seizure list exhibit 9 in presence of the witnesses. In TI parade, properly conducted by PW14 on 18/4/94 after 14 days. These seized saree were identified by PW2 and 3 have been stolen away from their house by the dacoits. These sarees have been released in Jima PW1. According to PW3, because she was using those sarees, she was able to identify them in the TI parade. It is thus doubtless that some of the stolen articles were recovered at the instance of appellants, Nitya and the two petitioners from their house after 3 days of the occurrence. These 2 appellants do not pleaded that they received the saree from somebody else. On the basis of these 2 sarees, they have been convicted, and that is also in presumption manner. That is, on this 2 lines thereafter, that is recovered on the presumption.
They modified the sentence. Because this appeal, this revision has remained pending for 27 years.
They
were on bail.
They are on bail, and that will not see consider accordingly. And they go through the LCR, it will be revealed that how many days he is in custody.
How many days?
Well, as per my instruction, I have already there mentioned in my bail application, half of the sentence they have already there in custody. More than 2.5 years they are in custody. In my bail petition, I have stated my letter.
In the trial court's order, it also shall be set up. They are bound to remain custody in that point of time. So period they have undergone. Out of 5 years, how many that but must be 1 and 2 years like that. Okay. 1 or 2 years out of 5 years they have spent inside jail.
Specific area of detention is necessary, my lord. Only to verify the LCR, it will come to light. How many days they were in custody?
You were saying 3.5 years or something.
2.5 years.
That was saying 2.5.
Then half of the period that I have mentioned in my bail application at that time. Probably from ascertaining from the persons that have been mentioned, manner, 2.5 more than 2.5 years must have been there in custody.
In both the cases.
No, these my two petitions in first case.
Can you find out? How can you find out?
From LCR it can be.
Even the report is called for from the jail.
LCR is here.
Now get this.
Huh?
Soft copy.
Soft copy.
LCR you can find.
Where?
This one.
मतलब सॉफ्ट कॉपी ऑफ LCR is available.
Cannot read it.
Don't say 9, try put 2. Don't say try put 9. हमको इधर लिखा था इसमें का बिजली लिखा था एक पिक्चर में इससे लिखा था
After when was the appeal filed?
G8 1995. They have been broadcast. It is a trial court. Then appeal was paid. April 96.
Occurrence होची 94 में 23 94
Bail free again.
Occurrence 94.
All along whether they were facing trial without bail.
Revision applications have been filed
95.
under section 397, read with section 401 of the CRPC, putting to challenge an order, a judgment of the learned session judge Karapot, dated
Dated 30th
30
March 1996.
30 March 1996, whereby the learned appellate court confirmed the judgment passed by the learned Chief Judicial Magistrate cum Assistant Sessions Judge Jaipur, in Sessions case number 74/94 and 23/1995. Is it correct?
No, it's 3/8/1993. Sessions case number is
The-
74.
Trial court
74/94. 74/93. Read it.
by
Read it. 24.
its judgment dated 3/8/1995 hailed the petitioners guilty of the offences punishable under section 395 of the IPC and sentenced them to imprisonment for 5 years with a fine of rupees, rigorous imprisonment for 5 years with fine of rupees 500 each, and in default to undergo rigorous imprisonment for 1 month. Stop. The occurrence is of 1994. Learned counsel appearing on behalf of the petitioners have argued that during the pendency of the appeal, the appellants were in custody.
Pendants of the appeal, my lord, in my case, they were released, in his case, I don't.
2 years is there, 94, 96 appeal is before. Then they are in custody as per their submission.
No, after conviction, you were in custody.
No, after conviction was in custody, again released by the appellate court. In total, my lord, it will be around 2 years, my lord, because trial stage, my lord, no bail, nothing like that. In my case, because I am in a different case now.
Petitioners have argued that instead of entering into the merits of the case as regards the correctness of the petitioner's conviction, this court may consider modifying the sentence to the period already undergone by them. So stop. Next. Do you have any objection?
No, my lord,
Learned public prosecutor
I
representing
objection
the
may be reflected. You will see that.
learned public prosecutor has submitted that considering that the finding of conviction recorded by the trial court, confirmed by the appellate court, is based on due appreciation of evidence adduced at the trial. So, however, considering the fact that the appellants that the petitioners were convicted in 1994 to undergo imprisonment.
My lord, 95.
1995.
Occurrence of the year 94.
1995. Sorry.
Convicted 1995, occurrence of the year 94.
No. The trial court's order is obviously 1995. And this revision application has remained pending before this court for nearly 27 years, comma, in the interest of justice, without interfering with the finding of conviction recorded by the trial court. The period of sentence is hereby modified to the period already undergone by the petitioners. These revision applications stand disposed of accordingly.
My lord, the 5 years, 1,000, default sentence is 2 months. And session case, other numbers should vary.
In the
So-
first case, first case.
Is it
In the first case, this order is your case. Second case, no. Only one appellant.
One. Trial court, page 11,
1,000
1,000,
plus.
default sentence 2 months if non-payment. And sessions case, other things should differ.
Sessions case. Sessions case,
Sessions case, number 10 of 96.
10 of 96.
Date is also different.
Date of
Date of order is also different. Look at disposal. Sessions case disposal is also different. My lord. Sessions case number is 10 by.
what is the date?
Date is 16 July 97. Oh, like,
13/7 election.
Huh?
13/7 election. 13/7/2004.
no. The court was the appellate court.
Yeah.
Appellate court. That is appellate court. That is trial court, I mean. Trial court also sessions case number is there. Hello, copy of the order.
Yes.
Of that.
Item 11.
May I please, your lordship? Here, my lord, your lordship kindly note this revision is against conviction for the offence under 307 and 341. I am, my lord, only confining for the accused petitioner number 2, Nageshwar Sethi, my lord. As because petitioner number 1, as per order of this honorable court, already served the sentence. And that case was disposed of there.
It is, my lord, in the year 3/11/1989, the occurrence took place. The allegation is that 5 brothers, my lord, they are accused. They came for hold the injured, and one Ishwara Sethi, who is, my lord, petitioner number 1 here, already served the sentence. He, my lord, assaulted. And the sentence, no, Ishwara Sethi subsequently murdered. And in the meantime, my lord, out of 5 accused, my lord, 3 already died, my lord, including that Ishwara Sethi, my lord.
3 out of 5, 3 died.
My lord. Out of 5, my lord, 3, all are brothers, my lord. One injury, my lord, is there. As per there is 6, my lord, witnesses examined in the case. Out of 6, my lord, PW1 is the doctor, PW2 is the injured, and the 3, 4, 5 are the 5 is the scribe of the FIR. 5 is the scribe of the FIR, my lord. The scribe of the FIR, my lord. And 6 is the IO.
PW1 and PW2 are?
PW1 is the doctor, my lord, who examined the injured, my lord. And who opined that only one injury, that is grievous in nature, which assaulted by Ishwara Sethi, and that injury.
Yes.
No. And
There is no witness.
my lord,
There is no witness.
my lord, other witnesses, my lord, not supported the prosecution case only on the basis of the injured PW2, my lord. The case, my lord, convicted. Initially, the case was acquitted by all the accused persons by the sessions court. The informant, my lord, preferred an appeal here. This honorable court directed the London trial court to rehear the matter. After rehearing, my lord, again conviction order passed against all the accused persons who preferred the revision. Out of 2, my lord.
But the victim, the injured is which PW?
PW2, my lord. PW2 is the.
So what did he say about you?
My lord, not saying anything, said that 5 persons came to throw a hole and the Ishwara Sethi assaulted. That is the specific allegation of.
If they fought hold, then the offense is.
On the basis of adding 34, my lord, we are implicated. But he has not stated anything about who cut out the. He has not stated, my lord. In the clause, he has not stated, only stated that I cannot say who cut out me. But
then he is truthful. But what is your what was the sentence?
My lord, sentence is 3 years for the offence under section 307. And so far as 341 is concerned, my lord, only simple imprisonment of RI.
And you have remained in custody for.
Yes, my lord. What happened here, my lord? During course of my lord, appellate stage, my lord, I have remained in custody 17 days. Thereafter, NPW issue after when, my lord, the order of this honorable court passed directing, my lord, the so far Ishwara Sethi is concerned. Thereafter, my lord, NPW issue and the petitioner now in custody since 12/6/2023, my lord.
12/6/2023,
my lord. This is the order of certificate copy of lordship, kindly see. Near about 1 year now he is in custody, my lord. Out of 3. Here also I find, my lord, one thing, my lord, if that will be considered, my lord, then the injury, my lord, sustained by the injury is not caused by this the accused persons, my lord. As because the FIR, my lord, it is reported on 3/11/87 at about 1:30 p.m. But the doctor, my lord, PW1, he stated, my lord, that.
And what happened to 3 other persons?
3 other persons, 3 my lord died.
He died during the pendency of trial.
No, my lord. During pendency of appeal, 1 died. During pendency of revision, 1 died. Ishwara Sethi died during pendency of this revision. And another brother died after serving the sentence, my lord.
5 brothers
My lord, there are 5 brothers. 5 accused persons are 5 brothers.
were made accused in what is the FIR?
My lord, FIR is in the LCR, my lord, that is soft copy. Get it? Page 75 of the LCR, your lordship kindly see. Soft copy, page 75. 75.
What is the PS case?
PS case, my lord, it is Malkanagiri, PS case number 133 oblique 1987.
Malkanagiri PS case number
133, 1987.
registered for commission of offence punishable under section
307,
307, 341 read with 34 of the IPC, which finally gave rise to Sessions case number 17 of 1998. So, it was the prosecution's case that petitioner number 1 and petitioner number 1 with petitioner number 2 and other 3 brothers assaulted the injured PW2 with an intention to kill him. Stop. The allegation of kill him. The trial court held petitioner number 1. Trial court concluded on appreciation of evidence that the petitioner number 1 had assaulted the injured bracketed PW2 when the other accused persons had caught hold of him. Stop. Petitioner number 1 has been released as after having hailed the it is an admitted fact that 3 out of the 5 persons named in the FIR died either during the pendency of trial or appeal filed before this court against initial judgment of acquittal recorded by the trial court. Stop. It may be noted that the trial court had earlier recorded acquittal of all the persons charged of the offence, but on an appeal preferred by on a revision preferred by the informant. Informant before this court, the matter was remanded back to the trial court.
Paragraph 6.
Whereafter the trial court recorded conviction of very rare a recorded conviction of all the five. All the five were.
In the record, I hold the accused person guilty under section 341, 307, read with section 34 of the Indian Penal Code and convicted them thereunder.
No, but the all the five were alive.
My lord.
Independency also in course of investigation काट देना यहाँ पे. Petition number 1 is Ishwar Sethi.
My lord, Ishwar Sethi. He died on 25/5/2011, my lord. While this revision was pending.
Where is the order of the trial court?
Trial court, my lord, in the revision, first order is the trial court order, my lord. Page number 18 is the order of sentence, my lord, and the 17 is the order.
Tell me again. A recorded conviction of the persons charged of the respective offense, charge of the offenses. Whereafter, full stop. Thereafter, the trial court by judgment dated. What is the date?
24/8/1994, my lord.
24/8/1994. The accused persons guilty of the offences punishable under section 341 and 307 of 7, read with 34 of the IPC. Stop. After having held the accused persons guilty, the trial court sentenced them to imprisonment, to 7 days rigorous imprisonment. Sorry. To 3 years rigorous imprisonment for the offence punishable under section 307 of the IPC, and a fine of ₹500 for the offence punishable under section 341 of the IPC. Stop. An appeal was preferred against the said judgment of conviction and the order of sentence, which has been dismissed,
Well, the order was confirmed.
which
Appeal
came to be
was dismissed.
dismissed by the appellate court below, confirming the judgment of conviction and the order of sentence. First off, present criminal division has been filed under section 397 and 401 of the CRPC, assailing the order passed. Where is the appellate order?
Appellate order is next, my lord, after the order of the trial court, that the appellate court order, you will also kindly see paragraph 10, page 7. That is the finding, and thereafter on 38/1999.
Assailing the order passed by the learned additional session judge Malkan Giri, dated 30/8/1999, in criminal appeal 10 of 1999, whereby the judgment of conviction passed by judgment of conviction and the order of sentence passed by the learned trial court has been affirmed. First off, next, learned counsel appearing on behalf of the petitioner number 2 has submitted that at the trial there were altogether 6 witnesses were examined, including the Dr. PW1, the scribes of the FIR, bracketed PWs 3, 4, and 5.
Only 5 men.
3 and 4, who are 3 and 4?
They are the independent witnesses.
They supported.
No, not supported.
Again? Including the doctor, bracketed PW1, scribe, bracketed PW5, and the investigating officer, bracketed PW6. First off, PW2, the injured witness, supported the prosecution's case, whereas other independent witnesses, namely PWs 3 and 4, did not support the prosecution's case at the trial. First off, he submits that apparently the finding of conviction is based on the sole evidence of based on evidence of the sole witness, that is PW2. First off, learned public prosecutor representing the state of Bihar has, however, state of Odisha has submitted that there being concurrent finding of fact recorded by the trial court and the appellate court, this court exercising divisional jurisdiction may not interfere with such finding, as the finding cannot be said to be perverse without any evidence. So, next, it is noted that an alternative submission has been advanced in behalf of the appellant, that the date of occurrence of the present case is
1989, madam.
date is 19
3/11/1989.
3/11/1989. Stop. This revision application has remained pending before this court for 20 for nearly 24 years.
20 years.
Nearly 24 years.
24 years.
Some 24 years. So, in such circumstance, comma as the petitioner number 2 has been sentenced to undergo imprisonment for a term of 3 years. This court may consider modifying the sentence to period of custody already undergone by him. Stop considering the facts and circumstances of the case. This revision application is disposed of by modifying the order of sentence. The sentence without interfering with the finding recorded by the trial court. Stop. The period of sentence as awarded by the trial court stands modified to the period of custody already undergone by the petitioners. Stop. This revision application stands disposed of accordingly.
Since he is in custody, your lordship, I will take to Salah. Only one petition. Because out of the 2 petitions, one day during 10 years. And 1 minute, since he is in custody, your lordship directed for immediate release.
Petitioner number 1 is dead.
No. During
Petitioner number 1 has served the sentence.
My lord, serve the sentence and after the serving. Only petition of 2 man.
Openly though, okay. Petitioner number 1. So it has been stated at the bar that the petitioner number 1 has died during the pendency of revision application. So, बाकी petitioner number 2 का लिखो, check करा दूंगी. Yes. He is in custody.
Yes, my lord. Now he is in custody. I have given the order, my lord. Your lordship direct. Subsequent warrant has been issued and he was in.
Consequently, they will consequently let the petitioner number 2 be next. It has been stated
Second
by learned counsel for the petitioner number 2 that petitioner number 2 has been taken into custody
Madam.
recently on
12/6/23, my lord. The second order. 12/6/2023.
12/6/2023, and he is presently in custody.
Madam.
Let him be released forthwith.
I beg your pardon to mention before your lordships. Item number 5, your lordships may kindly grant me liberty to renew my prayer after framing of charge, your lordships.
Liberty has been granted.
After 6 months, your lordship.
Yes. Not criminal.
Bless lordship.
Item 12. Item number 12.
Yes.
Arrived for 2 years. Appeal confirmed. None person present. None appeals. Arrived for 2 years.
We are adjourning the matter,
No.
but in the meanwhile, please inquire whether he
The
is
person
alive
is-
or not.
Well-being of
There
the
is no representation on behalf of the petitioner. Will is this matter on next Friday?
May Christmas. Lords of, being pleased to refer this matter to this larger bench on 3 questions, because which is at page 26 of that judgment, Bullets. If I may place those questions that have been framed by your lordships.
Just.
Yes,
Mr. Acharya, just one moment.
my lords.
This court, in the case of Leela Aditya Dev, relying on the decision of the Kerala High Court,
My lords.
has decided whatever you has been referred. But after that, that lot shipping company had that judgment has been delivered. That has not been taken into notice.
No, that's,
Oh.
that's what happened really. KCS was the first judgment. KCS referred to URC of Kerala High Court. URC has been overruled by lot shipping.
That is before that Leela Aditya.
Yes, but Leela relied upon KCS.
Yes.
One of the questions that have been framed by your lordships is at page 26 of that judgment, para 13.
So the IR will be 25.
Yes. Judgment dated 12th of April.
Yes. Yes, still there.
Whether the meaning of the word court under the provisions of the Arbitration Conciliation Act should be the same as defined under section 21E thereof, irrespective of the context in which the said word has been used. Second question, whether the term court contained in 29A, 4 and 5 of the Act in the case of domestic arbitration shall mean the High Court applying the rule of contextual interpretation as permitted by the Act itself in its definition clause under section 2(1) thereof. Third question, Millet, whether the decisions of this court in KCS and Leela Aditya lay down the correct law on the point of interpretation of the word court under section 29A, 4 and 29A, 5 of the Act. As your lordships have rightly indicated.
So these are 4 questions.
3 questions.
So these are 3 questions.
Yes.
Once these questions are answered, Mr. Thakkar is also there.
Yes, please.
So if these questions, these questions are answered, we believe the controversy will be set at rest.
Yes, your lordships are right. Absolutely.
Yes. Please.
Yes. Now let's asked about the questions which have been framed. Malad are asking the questions. I'm appearing in matter when Mr. Thakkar is there for the respondents. Although I do not, I also want an extension. We are not opposing each other. We are not, I'm not in opposition of Mr. Thakkar. So, but on the question of the questions framed, there might be another judgment which was passed by the Bombay High Court on 15th of April, which your lordship may have to take into consideration framing of the question, because it fell from your lordship whether the questions answered. So that may come to your lordship's consideration for framing of the question, because there are a couple of aspects.
No,
which obviously
questions have been framed.
I understand.
Questions have been framed.
Yes.
Those questions have to be answered by the revision bench.
Yes.
While answering that, those questions, if any ancillary question arises, that can be considered. That can.
I don't have problem. Let's look at Bombay judgment. Let's
therefore, the revision bench is set.
Whereas Bombay High Court judgment, what it did, it considered procedural vista court, which your lordships have referred to in this judgment, but found that there was an earlier judgment of Mormugai Court, which spoke otherwise. So, Millets, in the interest of judicial discipline, Millets, the Bombay High Court has referred the matter to a larger bench as the Allahabad High Court. And the questions, Millets, will find at page 24.
Yes.
What my learned friend Mr. Monty is indicating.
What are the questions?
You will actually see at page 24. 24 of that judgment at para 39. Those questions, please.
Para 39.
39 of that judgment, let's at the very end, second last page, please.
Yes.
In the event an arbitral tribunal constituted by the High Court under section 11(6) fails to complete the proceedings within the stipulated period or extended period,
where an application under section 29A4 would lie. The High Court.
The second question arises in these proceedings.
No, in my case, at least it doesn't arise.
So whether in your case, the second question arises.
No, my lord. No, my lord. So, that is a question that is better left to be adjudicated in some other case. Maybe your lordship, because your lordships are hearing the matter, we just thought it would be better if your lordship knows what's the ambit and the ambit of what your lordship are deciding. Remember, there might be tomorrow there might be a distinction.
We don't know.
I can believe about it.
To decide
I can believe about it.
what may come in the future.
No, I can believe about it. Insofar as starting off from the judgments of KCS and Illavitya, while in my humble submission, they may not be laying down the correct provision of law, is because they miss out on the point that the phrase unless the context otherwise requires, this contextual interpretation imparted to the definitions, that has been left from consideration. And if this aspect is not considered, then what will happen? Court, the definition of court would therefore mean for all purposes for principal civil code.
Yes.
So therefore, those judgments of this honorable court with great respect may not be laying down the correct position of laws. Now, contextual interpretation, I'll straight away take your lordships.
Just.
Yes.
The 29A came into the statute book in 2015.
My lord.
So, and there has been an amendment in 2018.
19.
So that's regarding international arbitration. I'm
Yes.
missing more. That's all.
Yes, that's it.
Before 2019.
Online. Library must be has.
Let's make it total lordships to the president itself, which is the seminal question arising before lordships. Section 29A. The subsection 4. If the award is not made within the period specified in subsection 1 or the extended period specified under subsection 3, the mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified extended the period. Provided that while extending the period under this subsection, if the court finds that the proceedings have been delayed for the reasons attributable to the arbitral tribunal, then it may order reduction of fees of arbitrators by not exceeding 5% for each month of such delay. Provided further that where an application under subsection 5 is pending, the mandate of the arbitrator shall continue till disposal of the said application. Provide also that the arbitrator shall be given an opportunity of being heard before the fees is reduced. That's subsection 5. The extension of period referred to in subsection 4 on the application of any of the parties and granted only for sufficient cause and on such terms and conditions as may be imposed by the court. Subsection 6 means. While extending the period referred to in subsection 4, it shall be open to the court to substitute one or all of the arbitrators, and if one or all of the arbitrators are substituted, the arbitral proceedings shall continue from the stage already reached and on the basis of the evidence and record, and the arbitrators appointed under this section, plus arbitrators appointed under this section, shall be deemed to have received the said evidence and material. Now let's subsection 7. In the event of arbitrators being appointed under this section. So Subsection 7 says, in the event of arbitrators being appointed under this section, the arbitral tribunal thus reconstituted shall be deemed to be in continuation of the previously appointed tribunal. So let's here, if I will take a pause, let's substitution comes together with the consequent appointment.
इसके पहले का मैंने बोला yes.
So let's, my humble submission is substitution comes together with the consequent appointment, and appointment in this case under where 11.6 has been there has been a 11.6 appointment.
Yes.
Therefore, the powers of 29A for the purpose of extension of the award, extension of the time period for the passing of the award, where an appointment of the arbitrator has been done under 11.6, has to be with the same appointing court. Am I clear on this?
Yes.
So let's, and also 29A7 also makes it clear that the tribunal thus reconstituted shall be deemed in continuation of the previously appointed tribunal. So let's if the power of extension under 29A4, which carries with it a power of substitution and an appointment, is to be read in a manner that it is the district court, then it will give rise to an anomalous situation where the appointment of the original arbitrator would be by the High Court, whereas the substituted arbitrator would be by the Honorable District Court.
Yeah.
Then let's another interest, and why I say let's is that context is very important. Is what I'm taking lordships to judgment, so lordships knows. In fact, my lord, the only chief justice judgment in which reference has been made. Plus, there itself, the principles of the contextual interpretation has been laid out. Let's a section 8A. Let's be kindly see. Which is very interesting. In fact, it occurred to me just yesterday. It is a section in the Act which extends only to Jammu and Kashmir. But for the purpose of interpretation, if I can refer to that. The Lordships has 8A.
Yes.
It's a state amendment for Jammu and Kashmir. May I please note?
Yes.
Power of the court seized of petitions under section 9 or 11 of the Act.
Just a minute. Just
Yes,
a minute.
absolutely.
8
capital A.
capital A. Not there in my book.
This is
All right, please place.
Let's
Please place.
yes, please.
2020.
Let's
2020.
If your lordship wants the book, my lord, with the 8A.
No, it is there. It must be there. It is there. Yes, please.
there must be a state amendment to the minutes. Yes. Power of the court seized of petitions under section 9, 11 of the Act, 9 or 11 of the Act to refer the dispute to mediation or conciliation. If during the pendency of petitions under section 9 or 11 of the Act, it appears to the court that there exists elements of a settlement which may be acceptable to the parties, the court may, with the consent of parties, refer the parties for resolution of their disputes to mediation or conciliation. The procedure for reference of a dispute to mediation is as under. Let's what the procedure may not be relevant. What I wish to submit is that if
Mr. Counsel, the question is as to whether while interpreting a central act, should the court take aid of state act, that is had it been, if these amendments been introduced by a central act, the matter would have been different.
Only thing, may I say,
State act cannot alter the whatever. Your submission may be otherwise valid, but may not be valid with reference to this provision.
I completely bow down to your lordship's observation. It's only an analogy that I am giving. Why?
Why? Because you want to say that even Jammu and Kashmir people are also thinking similarly.
No, what I wish to submit is, your lordship will see it refers to the principal act.
Refers to the principal act.
And there,
state act is state act.
I completely bow down, What I submit, there the power of section 11 is from the central act.
We do appreciate that.
But there, the court, the reference to court means the High Court. Because section 11, 6 is a power of the High Court.
Again, I'm repeating the same thing that we are interpreting central act. Cannot take aid of that is an external source. External source in the nature of state act may not be useful.
But the only thing that this state amendment arises from that central act.
Therefore,
yes,
therefore, state act is state act. After all, it's under the legislative power of the state legislature. Not. And suppose we are giving you another example. So suppose similar provision is there in any other enactment. So can we, had it been General Clause Act, the matter would have been different. But can we take off some other provision in other enactment to interpret the provision under the present act? So we will have to look into this only.
Yes, only thing that I bring your lordship's attention is that it is not a straitjacket definition that court shall always mean district court. And therefore, a contextual interpretation has to be used.
Finally, your entire submission would revolve around the first expression used in section 2, unless context otherwise requires. So the whole has to be seen in that background.
In that regard, this judgment of your lordship's knows the celebrated judgment of Whirlpool, which also is a authority insofar as alternative remedy is concerned. That judgment has also referred to this contextual. Yes, please. 1998 SCC 1. Where what was being defined was tribunal. What will amount to a tribunal? So para 28, if I'm straight away take the lordships to.
Yes.
I'm sorry, para 23. Section 23 is the section, is the provision which was under consideration. It's under the Trademarks Act. Section 56, under which the notice to show cause has been issued.
No, you are referring to Whirlpool.
Yes, para 26.
Para 26.
23, I'm sorry, 23, not 26.
Yes. Yes.
Section 56, under which the notice to show cause has been issued to the appellant, provides as under power to cancel or vary registration and to rectify the register. 1. On application made in the prescribed manner to a High Court or to the registrar by any person agreed, the tribunal may make such order as it may think fit for the cancelling or varying the registration of a trademark on the ground of any contravention or failure to observe a condition incurred on the register in relation thereto. 1 minute.
any person aggrieved by the absence or omission from the register of any entry or by any entry made in the register without sufficient cause or by any entry wrongly remaining on the register or by any error or defect in any entry in the register may apply in the prescribed manner to a high court or to the registrar, and the tribunal may make such order for making, expunging or waiving the entry as it may think fit. The tribunal may, in any proceeding under this section, decide any question that is necessary or expedient to decide in connection with the rectification of the register. Now, let's tribunal is defined at paragraph 25.
Yes.
Tribunal has been defined under section 21X as under. Tribunal means the registrar or as the case may be the high court before which the proceeding concerned is pending.
Oh, sure. All right. Yes.
Unless tribunal is defined, then let's paragraph 28, the principles laid down. May I please note?
Yes.
Now, the principle is that all statutory definitions have to be read subject to the qualification variously expressed in the definition clauses which created them. And it may be that even where the definition is exhaustive, inasmuch as the word defined is said to mean a certain thing, it is possible for the word to have a somewhat different meaning in different sections of the act, depending upon the subject or context. That is why all definitions in statutes generally begin with the qualifying words similar to the words used in the present case, namely, unless there is anything repugnant in the subject or context. Thus, there may be sections in the Act where the meaning may have to be departed from on account of the subject or context in which the word had been used, and that will be given effect to the opening sentence in the definition section, unless there is anything repugnant in the subject or context. In view of this qualification, the court has not only to look at the words, but also to look at the context, the collocation and the object of such words relating to such matter, and interpret the meaning conveyed by the use of the words under these circumstances. Paragraph 30 minutes, paragraph 29 minutes. Before considering the contextual aspect of the definition of tribunal, first consider tribunal and simple. Here, the tribunal is discuss what is the meaning of the tribunal. Then let's paragraph 30. Since tribunal is defined in section 2, which in its opening phrase uses the phrase unless the context otherwise requires, acting to Miller's the case before the lordships. The definition obviously cannot be read in isolation. The phrase unless the context otherwise requires is to prevent the person from falling into the whirlpool of definitions and not to look to other provisions of the law, which necessarily has to be done as the meaning ascribed to a definition can be adopted if the context does not otherwise require.
So this is from paragraph 23 to?
Now let's 23 to 30 minutes.
230. Yes.
Then let's, if I may take the lordships to para 62. In this background, the phrase before which the proceeding concerned is pending, your lordship found it? Ultimately, let's the Supreme Court rose on contextual interpretations. In this background, the phrase before which the proceeding concerned is pending stands out prominently to convey the idea that if the proceeding is pending before the registrar, it becomes a tribunal. Similarly, if the proceeding is pending with the High Court has to be treated as a tribunal. Plus, the High Court is treated as a tribunal in this case. Thus, the jurisdiction of the registrar and the High Court, though apparently concurrent in certain matters, is mutually exclusive. That is to say, if a particular proceeding is pending with the registrar, any other proceeding which proceeding will have to be initiated before and taken up by the registrar, and the High Court will act as the appellate authority of the registrar under section 109. Let's just reading few lines at the bottom. Any other interpretation of the definition, the election form?
Yes. 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 Yes Yes.
Any other interpretation of the definition of primary would not be in consonance with the scope of the act or the contextual background set out therein, and will lead to conflicting decisions on the same questions by the registrar and the High Court, besides generating a multiplicity of proceedings. Here also the contextual interpretation was similar opening line in the definition section was there. The Honorable Supreme Court has laid down the law that you have to impart, you can't have a straitjacket formula. Then there's another judgment of K.V. Muthu. This is the definition of family.
Yes.
And that will finally come to para 8, 8 to 13. Learned counsel for the appellant has contended that family has to be given the meaning which is commonly understood by an ordinary man. Therefore, family will include actual sons and not foster sons.
Which paragraph?
Para 8 minutes.
8. Yes.
The learned counsel for the respondent, on the contrary, contends that since the definition of family as set out in the act is an artificial definition, its natural or common meaning cannot be adopted. Family, it is contended, is a word of great flexibility and has to be interpreted in the context of the act, with the result that maintaining those related by blood and marriage, but others will eventually be interpreted. So, para 9, section 26A provides as under. Number of appeals as section is quoted. Para 10 minutes. Apparently, it appears the definition is conclusive as the word means has been used to specify the members, namely spouse, son, daughter, grandchild, or dependent parent who will constitute the family. Section 2 of the Act, in which various terms have been defined in this Act, unless the context otherwise requires, which indicates that definitions, as for example, that of family, which are indicated to be conclusive, may not be treated to be conclusive if it was otherwise required by the context. This implies that definition, like any other word in the statute, has to be read in the light of the context and the scheme of the act as also the object for which the act was made by the legislature. While interpreting a definition, it has to be borne in mind the interpretation placed on it should not be cognizant to the context. It should also be such as would aid the achievement of the purpose which is sought to be served by the act. The construction which would defeat or was likely to defeat the purpose of the act has to be ignored and not accepted. Where the definition or expression, as in the instant case, is preceded by the words, unless the context otherwise requires, the said definition set out in the section is to be applied and given effect to. But this way, which is the normal meaning, departed from if there be something in the context to show that the definition could not be applied. This court in K. Balakrishna Rao, such and such much, while considering the definition clause of this act, which is under our consideration, the definition clause does not necessarily in any statute apply in all possible contexts in which the word which is defined will be found therein. Section 2 of the Principal Act itself suggests that any expression defined in that section should be given the meaning assigned to it when unless the context otherwise. Whereas on a contextual interpretation part, these are the two judgments. There are, of course, your lordships have quoted that phrase from Reserve Bank of India in the referring judgment, which says that while context is the color, the text is the texture. Plus, nothing could be better expressed. It can't be better expressed than this. So, apart from that, there's the judgment of JP, Allahabad High Court's referring judgment. That also discusses upon the perspective of context. If your lordship wants, I'll read out and if I indicate that judgment, JP lordship. That's it must be there in the must be there in the
29, I think.
yes, so JP is the must be there in the file. That's the judgment referring the matter to a larger bench in Allahabad High Court. There, if I may just read out,
Yes.
Para 26. Generally, while interpreting a particular term of the statute, courts tend to defer to the meaning of that term provided in the definition clause. The definition clause is a crucial component of any statute or legislation. While it may appear to be introductory section, the definition clause plays a critical role in providing clarity, consistency in the application and implementation of the statute. Its importance cannot be overstated as it significantly influences the understanding and implementation of the law by the courts, legal professionals, and individuals or entities affected by the statute. While the definition clause is a fundamental aspect of interpreting the statute, there are certain circumstances under which it may not be applied or given primacy in the interpretation process. One of these circumstances is contextual ambiguity.
Searching that. The cricket and that thing doesn't know. Keyboard.
One of the circumstances is contextual ambiguity. In some cases, the definition is
Reading which paragraph?
26.
26. But that is an opinion of
Yes,
a
Milord.
learned single judge.
Yes, your lordships can treat this as my arguments before election. One of the circumstances, contextual ambiguity. In some cases, the definition provided in the statute's definition clause may not fully address the ambiguity or uncertainty present in the statutory provision. Courts may beyond the definition clause and consider extrinsic sources such as legislative history, statutory purpose, and the context of the provision to ascertain the legislature's intent. To mind,
Just a minute, just a minute.
my lords.
Of Allahabad refers to the background in which the amendments were introduced.
The amendment plus. 21 minutes we discuss on the law commission report plus.
Where is it?
Plus that. Para 16 minutes.
There are 62. Just a
Refer to the 176th law commission. From para 16.
yes.
That is the law commission report, which led to the production of 29 notes. Although that law commission report was of 2001, that it was not included till 2015. So 346 law commission report is not what forms the basis of 29 notes. And your lordships must have noted was the future procedure that high courts will, that the last observation was in that law commission report. It's by Justice B.P. Jivan Reddy, as he then would say.
No, sir. 11.6. Yeah.
Now let's this judgment of the Allahabad High Court. Let's discuss it. I'm just pointing out the paras. Para 26, 39, 40, and 56. They deal with the aspect of contextual interpretation. Para 56 is the principles. Although it's a single judge judgment, but your lordships can treat this as my argument. Para 56b says, when the phrase, unless the context otherwise, this is a conclusion, unless the context otherwise requires, precedes a definition clause that acknowledges the varying circumstances that may arise in a particular statute, which may necessitate according to a different term than the one that has been provided in the definition clause. If a particular term has to be accorded the same meaning throughout the statute, even if it leads to repugnancy and absurdity, the use of phrase unless the context otherwise requires would become odious. So, plus, if that straitjacket definition of court is to be treated as district court, plus, in that event, what will happen? The opening phrase would be rendered redundant. That would be all insofar as
any opposition to this.
Well, I wouldn't say there's an opposition to it, but I just wanted to bring to your lordship notice that what we're discussing here might have some ramification to other sections of your lordship. Once, as your lordship started by saying, those are not questions before this court at this point of time, being these questions.
You will not enter into any question which
Correct.
is not
before this court. Then I don't think so.
not go.
Correct. Well, then I don't think so. I would stand on the same footing. As I said, one of the two.
No, what we are saying, that is there any opposition to the submissions which are being advanced? That no court will mean court as defined under section 2(1)(e). Is there any?
Well, as I said, may not be under the context of 29A, just one point, just a thing on 29A, is 4 and 5 that we read out. Malab also keeps in mind that these may not only be summary proceedings or only an extension, because your lordship also has power under 29(4) and 29(5) to probably, if I may use the word, penalize the arbitrator, because there is a term that if your lordship finds that delays because of the arbitrator, then your lordship also penalizes it, and the word fine would also be a judicial process. Now, that's number one. So your lordship will keep in mind this 29A4 and 29A5.
See, for that purpose, see the question number 1.
Yes, Lordship.
Number 1 does not refer to a particular provision or any, it is a general question. It does not say that court would be high court.
Contextually.
Says that, does that mean court as defined under 2(1)(e) only?
I am.
Not otherwise.
I am.
That is the first question.
Right.
And then the question of context will arise. So that this is how the question.
Well, as it has been decided, I just wanted to bring the lordship notice because now what we are discussing today, we have the benefit of other judgments around the country. So your lordship has the advantage of foresight that way. So what your lordship decides today, they might have ramifications. Just wanted to bring the lordship notice so your lordship knows it. As an officer of the court, I just process. For example, section 14. Section 14, what are we discussing today in terms of context? But listen, if an arbitrage tribunal or an arbitrator is appointed or constituted by this honorable court, then because of the definition starts with the context otherwise provides, then the extension should only be, the judicial propriety would demand that it would only be the high court and cannot be the lower court. Now, if we stick to that understanding that because the context otherwise provides and the court should mean high court, then section 14, my lord.
We are on to section 14. We are confined
to section
29. A4.
Correct.
And for that purpose, we have framed the first question.
I bought on.
So that first question also is confined to.
Then I completely bought on. Then I don't think so. We should be worried about other aspects. As and when it comes, that will be.
It's a kind of deductive logic.
Hello.
First, second, and third.
I bought on.
Sir, if I'll be failing in my duty not to point out section 15(2). 15 words, discusses about termination of mandate and substitution of arbitrator. Let's see 15.2. May I please note? Where the mandate of an arbitrator terminates, a substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator being replaced. So let's there also, if somebody is being replaced, which in this case is appointed under 11.6, the same thing will apply right with 29A7, where let's 29A7 also let's which I showed to your lordships. So 29A7 read with 15.2 will make it very clear that where the arbitrator is appointed by under 11.6, then the extension also will, as a natural consequence, be under the powers of the same court.
In that question, my lord, is your lordship's question number 2 that your lordship has framed, if I can read out the question, whether the term court contained in section 29A4 and section 29A5 of the Act in case of domestic arbitration shall mean the High Court applying the rule of contextual interpretation as permitted by the Act itself in its definition clause under section 2(1) thereof.
If answer to question number 1 is yes,
Yes, your lordship.
then only we can enter into answering.
I only want to assist your lordship that when we say domestic arbitration, then there might be two issues in that, because which emanates from 11.2 and which emanates from 11.6. As my learned friend said, that if it's under 11.6, then contextual interpretation would say that it is your lordship's High Court. But if it emanates from 11.2, so that means, my lord, if in the question of the question number 2, your lordship may consider capping it to 11.6, because then in that case there may not be any going further, there may not be any contradiction. But if your lordship keeps it wide enough to domestic arbitration, then it may also get into its ambit 11.2. That may create. That's my only submission. Because 11.2, your lordship may not have any relevance. Two parties are deciding on its own.
Yes.
Plus, that would be all. Other than that, plus the judgments, earlier judgments, and also plus there's a division bench judgment of Bihar, Patna High Court, plus South Bihar. Yes, so that judgment is also there, which discusses on this.
Yes, my lords. My lords, if I may only say this much, that in my respectful submission, my lords, question 2 also your lordships, in my respectful submission, ought to, my lords, answer, for the simple reason that, my lords, assume my case, my lords, for the moment, and take my case at the moment. In my case, my lords, the parties under 11.3, they had extended the period, not exceeding 6 months. That period got over. Post which, my lords, 11.4 kicks in, namely that, my lords, if the award has not been made within that period, my lords, then in that case, unless the court actually, my lords, either prior to or after the expiry of the period has extended, then, my lords, the mandate of the arbitrator would stand, my lords, extinguished. And that if your lordships now see 29.5, that in itself refers back to 29.4, to say that your lordships can, on a sufficient cause being shown, extend that period on conditions that are imposed by the term court, by the court. And then, my lords, section 6 says that while the period which is referred to in subsection 4, it shall be open for the court to substitute. In my respectful submission, my lords, that this is a case of a domestic arbitration. This is a case where 11.3 was followed. That period expired. Therefore, my lords, under 11.4, we are before your lordships for the purposes of seeking an extension, which your lordships may grant under 11.5. In my respectful submission, my lords, whether 11.3 or 11.4 or 5 or 6, either of those, my lords, will take color from the color from the context in which they are used. And, my lords, 11.6 makes it very clear that the term court, in the context in which it is used, more, my learned friend has already argued it, I don't need to repeat it. But the fact that that there is a substitution of an arbitrator, which either under section 15 or under 11 can only be done by the High Court. In my respectful submission, the term court will have to be read as the High Court, whether under 11, whether under 29A 3, 4, 5 or 6. That is my submission. So even if your lordships were to answer question number 1, even then, in my respectful submission, 2 needs to be answered. That's my submission.
Yes. We can answer question number 2 only if we answer question number 1.
Yes. Obviously, obviously, if your lordships are against us on 1, then
that is the reason why question number 1 has been framed.
Yes.
If we find the answer to question number 1 is negative, then there is no need of
absolutely.
Well, I think all of us join first question. We have not issued. I think Mr. Thakur got me wrong. I said 11.3, not 29.3. 11.2, my lord, the context, we are only deciding this context because all the judgments are consistent on that view. But we are taking the aid of context because it is the High Court who has either appointed or has appointed the arbitrator or the tribunal. So hence under 11.6, appointment is only under 11.6. So hence contextually it should be the High Court for 29A. But so my point is, your lordship may point this case to under 11.6. Because if your lordship keeps it wide for domestic arbitration, then the dispute may be that tomorrow there might be a case for under 11.2, where a person who has both parties are appointed, they have not come to court for appointment. So in that case, the context might say that, listen, High Court never appointed it, so High Court may not have a ground. In that context, it should be the district court or the commercial court. That is what I was saying, Madam. So the domestic arbitration wording in the question number 2 may be limited to 11.6. Gratefully.
My lords, I appear in item 50, my lords, for the respondent. I have only one submission to make in terms of the way the statute is structured, my lords. My lords, section 29A is not simply deciding or dealing with extension of time, but it also deals with various other aspects, including termination of mandate, substitution of of one of the arbitrator, or the reduction of fees of the arbitrator as well. And my lords, if you look at section 29A 6, 29A 6, my lords, it says it shall be open to the court to substitute one or all of the arbitrators. Therefore, there is a substitution power specifically conferred in 29A 6. And my lords, so therefore 29A 6 will have to be read with section 11, which deals with the appointment of arbitrators. And the second aspect, my lords, if you also look at 29A 7, it says in the event of arbitrators being appointed under this section. So therefore, my lords, the 29A 7 specifically uses the word appointed under this section. So thus substitution is in fact a fresh appointment as contemplated under section 11 of the said act. Section 11, my lords. So therefore, if originally the 29A, while extending the period of arbitration, the court has been conferred a power to either substitute or reconstitute the arbitral tribunal as well. So therefore, in a way, it has to be interpreted that it deals practically with the appointment of fresh arbitrators as well. So if in section 11, the power to appoint is conferred with the High Court, then the power to reconstitute or substitute an arbitrator cannot be conferred on a district court, but has to be the High Court. So it's on a reading of the statutory reading of the section as well, my lords.
My lords, one submission, my learned friend was referred to 11.2 vis-a-vis 11.6. It is my respectful submission that whether 11.2 or 11.6, in either circumstances, my lords, it will not make a difference. The definition of the court will remain, whether under, my lords, whether the parties appoint or, my lords, the High Court or the Supreme Court, my lords, in its wisdom, my lords, give the power over, my lords, to the institution for the purposes of appointment. In either circumstances, under 29A, because what will have to be, the word court will have to be read in that context. And in that context alone, that we are arguing. Because there cannot be a different court for the purpose. Assume for a moment that where two parties agree on an arbitrator. That's the appointment procedure which the parties have chosen. Then at some point in time, one of the arbitrator was to unfortunately pass away. And the parties are not able to agree on an appointment procedure. The natural consequence would be that they would approach your lordships under 11.6. So therefore, it will not make a difference whether it is 11.2 or 11.6 for the purposes of definition of the term court under 29A. Whether 11.2 or 11.6, the court will remain as the High Court. That is my respectful submission. It cannot be that it will have to be read different in a different context under 11.2 vis-a-vis 11.6.
Well, my humble submission is it might have to be contextual between the two. That is what I was saying.
Okay.
Because in the example that Mr. Thakur gave, if both parties decide on to arbitrator, but because he resigns or for some other difficulty to come to High Court for 11.6, then 6 is what they are activated.
We are reading the second summation. Second summation. Give your slip. Follow.
Much